Commissioner, I now call Ms Helen Troup from CMLA.
Ms Troup, could you come into the witness box, please? If you wouldn't mind standing a moment. Can I ask first whether you'd prefer to make an oath or take an affirmation?
An oath, thank you.
Swear the witness, please.
I swear by Almighty God
I swear by Almighty God
that the evidence I shall give
that the evidence I shall give
will be the truth,
will be the truth,
the whole truth,
the whole truth,
and nothing but the truth.
and nothing but the truth.
Thank you very much, Ms Troup. Do sit down. Yes, Mr Carker.
Thank you, sir. Ms Troup, would you please inform the Commission your full name?
Helen Troup,
And would you give the Commission your business address, please?
1 Harbour Street, Sydney.
You're here to give evidence in response to a summons issued to you by the Commission, is that correct?
Yes, that's correct.
Do you have the summons?
Yes, I do.
I attend to that.
Exhibit 6.136, the summons to Ms Troup.
Now, Ms Troup, in respect of rubric 6.17, you have made a statement.
That's
Is
correct.
that correct?
Yes.
And it bears the number CBA .9000.0104.2000.
Yes, it does.
Are the contents of that statement true and correct to the best of your knowledge and ability?
Yes.
I tender that, if the Commission pleases.
The statement of Ms Troup concerning rubric 6-17 dated, Mr Carker. Have we a date for the statement?
Yes, the latest one is dated yesterday, I believe, Your Honour. Sorry, sir. 7th of September.
Statement of Ms Troup concerning rubric 6-17 of 7 September 18, exhibit 6.137.
And Ms Troup, with respect to rubric 6.27, you made two statements, each concerning interactions with an insured of CommInsure. Is that correct?
Yes, it is.
Yes. The first one bears the number CBA 9000, 1000, and I should start again, 0114, 1000.
That's correct.
That's correct?
Yes.
And the second bears the number CBA 9000, 0113, 2000. Is that correct?
Yes, it is.
And the first of them is dated the 28th of August 2018.
Yes.
Is that correct?
Yes.
And the second is dated the 11th of September 2018.
Yes.
Yes. Are the contents of each of those statements true and correct to the best of your knowledge and belief?
Yes.
Yes, I tender those, if the Commission pleases.
The statement concerning rubric 6-27 of 28 August 18 of Ms Troup is exhibit 6.138. The statement concerning rubric 6-27 of Ms Troup of 11 September 18 is exhibit 6.139. Thank you, Mr Carker. Yes, Ms Orr.
Ms Troup, you've been the Executive General Manager of CommInsure since April 2014.
Yes, that's correct.
And CommInsure is the name of CBA's insurance business.
Yes.
And CBA has both a life insurance business and a general insurance business.
Yes.
And the life insurance business is run through a company called the Colonial Mutual Life Assurance Society Limited, or CMLA.
Yes.
And the general insurance business is run through a company called Commonwealth Insurance Limited.
Yes.
But they're both run under the CommInsure brand.
That's correct, yes.
All right. Now, as Executive General Manager of CommInsure, you're responsible for both the life insurance business and the general insurance business?
Yes, that's correct.
And what does your role involve? What are the key duties in your role?
Well, I guess I'm the most senior leader of both businesses, and I guess that if you put it into three categories, it's developing the strategy, implementing the strategy, and leading the people.
Now, you've been put forward by CBA to give evidence about CommInsure's life insurance business and about two specific claims made under CommInsure trauma policies.
Yes.
Now, in 2017, CBA sold its life insurance business to AIA,
Yes.
but at the moment that business is still part of CommInsure.
Yes, the transaction hasn't completed yet.
Do you know why CBA chose to sell its life insurance business?
I think it's part of the broader strategy of simplifying the bank.
Now, I want to begin by asking you about one of the two specific claims that you've dealt with by statements, and the claim that I want to start with is the claim of a customer who suffered a heart attack. And the name of the customer is the subject of a non-publication direction, so I'm going to just refer to him as the insured. But you understand who I'm referring to because it's the customer who had the heart attack.
Yes, I do.
Thank you. Now, the insured took out a total care plan policy with an entity called Colonial in 2000. Is that right?
Yes.
And what is the relationship between Colonial and CommInsure?
So CommInsure today is made up of a range of companies that have been acquired over its history. So Colonial is one of the old companies that is in the part of our history.
And the policy for the insured gave him three distinct types of benefits, and they're explained in the information brochure for the policy, which you've annexed to one of your statements.
That's correct, yes.
Can I take you to that document, which is CBA 0517 0211 0001? It's Exhibit 2 to your statement dealing with the insured. And we will see when that comes up that the brochure is dated November 99 to November 2000, so it would have been current when the insured took out the policy.
Yes.
And if we turn to 0022, we can see a key features statement for the total care plan policy. And under the heading, the plan, we see that the total care plan is a comprehensive insurance policy with three important benefits: life care, which pays a lump sum in the event of death or terminal illness; recuperator, which pays a lump sum on the occurrence of a specified medical condition; and permanent care, which pays a lump sum on total and permanent disablement. Now, the recuperator benefit, was that trauma cover?
Yes.
Yes. And the insured elected to have all three of these parts to his plan.
Yes.
And then if we look at 0025, we can see that the recuperator or trauma cover is explained. We see there towards the top on the left-hand side that recuperator pays a lump sum on the survival of the insured for 14 days after the occurrence of one of the following.
Yes.
See that?
Yes.
And the first heading on the list that follows is heart disorders. And under that we see heart attack. And we also see further down coronary artery angioplasty. And both of those have an asterisk next to them.
Yes.
And we can see in the next column where the asterisk leads us to a full description of the policy definitions begins on page 30, is above the asterisk. Then the asterisk says, no recuperator benefit is payable if any of the conditions marked with an asterisk occurs or first becomes apparent within 3 months, known as the qualifying period of the date recuperator was added or reinstated to the policy.
Yes.
And then if we turn to 0030, we can see a list of recuperator policy definitions. And in the second column, we can see the definition of heart attack. The
Yes.
death of part of the heart muscle, myocardium, as a result of inadequate blood supply. The diagnosis is based on clinical electrocardiogram, ECG, and biochemical assessments, with the following criteria being present. 1, an electrocardiogram showing changes resulting from this occurrence, and 2, a pathology test which confirms that cardiac enzymes have been elevated above generally accepted laboratory levels of normal. That was the definition of heart attack in the policy.
Yes, it was.
So if the insured suffered a heart attack as defined here, he would be entitled to the sum insured under the recuperator component of the policy.
That's correct.
Now, the insured selected the amount of $100,000 for the recuperator or trauma cover.
Yes, that's correct.
Now, if we stick with this page at the moment, we can see another relevant definition on this page, which is coronary artery angioplasty. The definition for that condition: this means the undergoing for the first time of angioplasty, atherectomy, laser therapy, or insertion of a stent to the coronary arteries that is considered necessary by a cardiologist to treat coronary artery disease. Payment is limited to the lesser of 10% of the sum insured, or $25,000. The sum insured is then reduced by the amount paid and the premium reduced accordingly. Other intra-arterial procedures or non-surgical techniques are specifically excluded. Benefits are only payable once under this condition. So we see from that if the insured had a coronary artery angioplasty, he would be entitled to a lesser benefit. In this case, it would have been $10,000, which was 10% of the $100,000 that he had as the sum insured.
That's correct, yes.
And finally, if we turn to 0034, under the heading Guarantee of Upgrade, we see that the insured was told if future versions of this product are introduced, your policy will automatically be upgraded to the new contract within a reasonable time frame, generally on the next policy anniversary date, provided the insured will not be disadvantaged by any terms and conditions of the new policy.
Yes.
So the medical definitions in the policy would be updated from time to time.
That's correct, yes.
And you tell us in your statement that if a medical definition was updated, the insured would be entitled to rely either on the definition that applied at the time of purchasing the policy or an updated definition. Is that right?
That's correct, yes.
And an insured person would not be, we see from this page, disadvantaged by any change of definition.
Yes.
Now, these terms that I've taken you to were reflected in the policy document itself, which you've also exhibited to your statement.
Yes.
Now, the definition of heart attack was updated over the following years, wasn't it?
Yes.
And you've set out the different definitions that applied in Annexure A to your statement. Can I take you to that? It's CBA 9000114 1000 at 1017 to 1018. (1017) to 1018. I apologise if I got the number wrong. We've got the first page up, Ms. Troup, and I think the second will be following. So we can see from the left-hand side at 1017 the definition of heart attack that applied when the insured took out the policy at the top of the page.
Yes.
And we can see that there was a change in October 2002
Yes.
and then a further change in July 2005.
Yes.
And then over the page, in August 2013, we can see that the name of the condition changed from heart attack to heart attack of specified severity.
Yes.
But the definition otherwise remained unchanged from the July 2005 definition.
That's right.
And then in March 2016, there was a further change to the definition.
Yes.
But other than the change to the name, there was no change to the definition during the period from July 2005 to March 2016.
That's right.
So almost 11 years.
Yes.
Now I'm going to come back to the reasons why that definition was not changed in that period. But if we look at the definition that applied during that 11-year period, between 2005 and 2016, we can see that it required medical evidence of a diagnosis based on either the elevation of cardiac enzyme CKMB or elevation in levels of troponin I greater than 2.0 micrograms per litre or troponin T greater than 0.6 micrograms per litre or their equivalent, and certain other things, or other medical evidence that would demonstrate damage had occurred to at least the same degree of severity as would be evidenced by the medical evidence required under the first bullet point.
Yes.
Now, I appreciate that you're not a doctor, and nor am I, Ms. Troup, but are you familiar in general terms with this definition?
Yes, as long as you don't get too specific, yes.
It'll be a race to see which of us knows least about these matters, Ms. Troup. One thing I do know, and you can correct me if I'm wrong, is that troponin is a protein that's found in heart cells. Is that right?
You might be ahead of me on that one. I understand it's something that is released into the bloodstream, so yes, I think we're both on the same path.
And that measurements of troponin levels can be used in the diagnosis of heart attacks. Is that right?
Yes.
And I'm going to come back to the definitions set out in this annexure, but I want to first continue with the case of the specific person, the insured, whose policy terms we were just looking at. That insured person made a claim under his policy in January 2014.
Yes.
And you've exhibited a copy of his claim form to your statement. It's Exhibit 5, CBA 1004 0096 0503. So this is the insured's claim form. And if we turn to the second page, 0504, we can see that this page is headed Details of Trauma Conditions Claimed, and the insured has ticked heart attack. Do you see that?
Yes, I do.
And recorded that he was hospitalised for this on the 5th of January 2014.
Yes.
And do you know, from the documents that you've annexed to your statement, I think you do, that upon being hospitalised, the insured was told that he would either need to have bypass surgery or have stents inserted.
Yes, that was what we were told, yes.
And he elected not to have bypass surgery, but to have the stents inserted, which happened in 3 separate operations over the following weeks.
Yes.
Now, on the next page, 0505, which is Details of Trauma Conditions Claimed Continued, we see that the insured has also ticked coronary artery angioplasty.
Yes.
Now, when CommInsure receives a claim under a life insurance policy like this one, the claim's assigned to a case manager, is that right?
Yes, that's correct.
And can you explain in general terms the process that the case manager who had this claim would have followed in assessing this claim?
Yes, well, the first step on receipt of the claims form would be to make an assessment of whether all the relevant medical material has been provided. So you're looking for the evidence of that relate to those definitions that we spoke of a few moments ago. If they feel that they need more information, they will go and seek that information either through the insured or through a hospital or doctor directly. Once they feel they've got enough information, particularly on trauma in general terms, it would then go to our medical officer to help with the assessment of how does the diagnostic results reflect in the definition for some advice. Then it would return to the case manager and use that to make a decision on whether to accept or decline the case. Then there are protocols in terms of delegations, so I'm not sure if you want me to continue.
No, I think that's fine. As to who can make the decision, is that what you mean?
Yeah, so if there's a recommendation, depending on their delegation, they may have to have someone else review that claim.
Mm-hmm. But at that point, the decision is made about whether to approve or deny the claim.
Well, if it has to go up a level for
Yes, I
delegations,
understand.
yes, but yes.
So it may go to another person to approve that decision, but that's the decision point. Is that right?
Yes, yeah.
So here, the insured was making a claim on the basis that he'd had a heart attack and coronary artery angioplasty, and therefore CommInsure assessed his claim against the definitions of those two conditions in the policy. Is that right?
Yes, that's right.
And the case manager sought the opinion of one of CommInsure's medical officers, Dr. Alan Carless, on that point.
Yes, that's correct.
What's the relationship between a case manager and a medical officer within CommInsure?
What do you mean by relationship? So,
They work independently from each other, is that right?
yes, so I would have to think about what period of time that is, but the medical officers report through a different team.
Mm-hmm.
I think at that time they came through a team called Business Services, which was different from the claims team.
Is the role of the medical officer to assist the case manager to understand the medical evidence, but it's the case manager who's ultimately responsible, if they have the appropriate delegations, for making the decision on the claim?
That's correct, yes.
Okay. Now, Dr. Carless's opinion was that the insured met the definition for coronary artery angioplasty,
That's right.
but that there was not enough evidence that he met the definition of heart attack.
That's right.
And the case manager told the insured this,
Yes, I believe so.
and the insured then provided more medical information to CommInsure.
Yes.
And after reviewing that further information, Dr. Carless's opinion was that the insured still didn't meet the definition of heart attack under the policy.
That's right.
And again, the insured was told that.
Yes.
And the insured then gave further medical information.
Yes.
And the information showed, among other things, that the insured's level of troponin I rose from 0.4 micrograms per litre to 1.9 micrograms per litre.
Yes.
And we saw from the definition of heart attack that the first way of meeting that definition was to have a level of troponin I greater than 2.0 micrograms a litre.
That's right.
And Dr. Carless considered this material again,
Yes.
and he asked for more information.
Yes, I must say I've probably lost track of the number of referrals, but if we're in the right line, yes, there were.
These are all referred to in your statement. Yes. I'm at paragraph 47, if
Thank
that
you.
assists in your statement
Thank
at the
you.
moment.
Yes.
And he considered the further information that was provided and gave another medical opinion.
Yes.
And you've exhibited a copy of that opinion to your statement. I want to take you to that. It's Exhibit 12, CBA 1004 0096 0964. And we can see from this document that it sets out the case manager's synopsis of the case and the medical officer's response. Is that right?
Yes.
And we see the medical officer's opinion at the bottom of the page, and perhaps if we could have the second page brought up on the other side of the screen, we see that he says right down the bottom of the page, on the evidence he has had a small rise in cardiac enzyme CK, but not any reported rise in CKMB, and a rise in troponin I, but to a level less than 2.0 micrograms per litre. There are no confirmatory new ECG changes supporting the diagnosis of myocardial infarction. Further investigations are not required to assist in determining the diagnosis. This does not meet the policy definition for heart attack of specified severity.
Yes.
So that was Dr. Carlos's opinion, and on the basis of that opinion, in April 2014, CommInsure denied the insured's claim to be paid the full trauma benefit on the basis of his heart attack because he didn't meet the heart attack policy definition.
That's right.
But CommInsure decided to pay a partial trauma benefit of $10,000 because he did meet the definition of coronary artery angioplasty.
That's right.
Now, after this, the insured got in touch with CommInsure. He said that he'd spoken to his GP, who was amazed that CBA did not pay under the heart attack definition. We know that from an email next to your statement. You've seen that?
Yes, I have.
And in response, CommInsure sent the insured a letter explaining the decision and responding to certain questions that the insured had posed, but no change was made to the decision.
That's right.
And then in June 2014, the insured made a complaint about CommInsure's decision.
Yes.
And that complaint was handled by CBA's Group Customer Relations team rather than CommInsure, is that right?
Yes, did you say July 2014? Is that what you said?
Yes, I did.
Yes.
In paragraph 68
That's right.
of your statement.
Yes. Thank you.
So the complaint was handled by the Group Customer Relations team, which is different to CommInsure, is that right?
Yes, from a reporting perspective, yes, they're in a
Yes.
different part of the group.
But part of CBA?
Yes.
Yes, so it was an internal dispute resolution process.
Yes.
So when a customer makes a complaint that relates to an insurance policy, is that complaint generally handled by the Group Customer Relations team?
Yes.
And what involvement does CommInsure have in the handling of that complaint?
Well, if GCR feel they need advice or opinions from CommInsure, they seek it. So it depends on the nature of the complaint.
So in this case, the decision remained after the complaint. A decision was made not to alter it.
That's right.
And the insured did not make a complaint to FOS at this time. I'll come to later events. And by July 2014, CommInsure considered that the case was resolved. Is that right?
Yes.
Then I want to take you forward a couple of years to March 2016. In the first week of March 2016, ABC's Four Corners program and Fairfax Media reported on concerns about CommInsure's life insurance business. Do you recall that?
Yes, I do.
And are you familiar with the media reports at that time?
Yes, I am.
You were the Executive General Manager at the time those reports were published.
Yes, I was.
And those media reports raised a number of concerns, and I don't intend to canvass all of them, but one of the concerns related to the definition of heart attack in CommInsure's trauma policies, and a concern that it was out of date.
That's correct.
And in particular, the concern was that the definition required troponin I levels of above 2.0 micrograms per litre.
That's right.
And that this requirement was out of date and didn't reflect developments in medical science.
That's right.
And on the 5th of March 2016, the day after the Four Corners program went to air, CommInsure issued a media release dealing with its product definitions.
Yes.
and you've annexed that media release to your statement. It's Exhibit 37, CBA 0001 0508 0647. Sorry, I'm just finding it, Ms Troup, because there are 7 documents annexed behind that tab of your statement, or perhaps there are 7, and it's the 7th document I'm going to. You can see it on the screen.
Yes.
And we see that the media release said in relation to the heart attack definition, do you see under the heading trauma heart attack definition, CommInsure's trauma heart attack definition pays for severe heart attacks and considers a range of medical factors when assessing a claim, not just the troponin levels. Medical advances and improvements in detection technology mean our current definition needs to be updated. We have already commenced work on updating this definition, and it was scheduled for implementation in October 2016. This has now been accelerated to be completed as soon as possible. So that was the information in the media release as of that date, the 5th of March. And then 5 days later, on the 10th of March, CommInsure issued another media release, which you've annexed to your statement. It's the 6th document behind this tab. CBA 0001 0508 0643. And if we turn to 0644, we see under the heading Improving Our Offer to Customers, CommInsure has accelerated the planned upgrade of its heart attack and severe rheumatoid arthritis definitions in its trauma product. This upgrade will be released in a product disclosure statement by the end of March, but coverage will be backdated and apply for all claim events from May 2014 onwards. May 2014 was the date of the last relevant product disclosure statement for the trauma product. CommInsure has also committed to a more regular review of the life insurance offering to ensure definitions reflect evolving medical standards and practices. So at the time of these reports, CMLA was already planning an update to its heart attack definition.
That's correct.
That update was due to take effect in October 2016.
Yes.
But CMLA decided to bring it forward to March 2016.
Yes.
And it decided to backdate the application of those changes to the 11th of May 2014.
Yes.
Now, I want to come back to that decision and deal with that in some detail a bit later. But we see from the annexure to your statement, which I had on the screen earlier, that the update occurred on the 10th of March 2016.
Yes.
The same date as this media release. And the new updated definition, which was backdated to May 2014, did not include the requirement for medical evidence that troponin I levels exceeded 2.0 micrograms per litre.
That's right.
Instead, it focused on a diagnosis confirmed by a cardiologist and evidenced by a typical rise and or fall of cardiac biomarkers with at least one value above the 99th percentile of the upper reference limit.
Yes.
And just to assist, I'll have that brought up onto the screen. CBA 9000 0114 1018 is the part of the annexure to your statement. And it's 1000, the first page of that document. We have it there. So we see the definition as of March 2016, no longer a requirement for troponin I levels to exceed 2.0 micrograms per litre. And we see instead a reference to at least one value above the 99th percentile of the upper reference limit for the cardiac biomarkers.
Yes.
Okay. Now, on the 9th of March 2016, the day before this, and a few days after the media reports were published, the insured who we were discussing earlier made a complaint to the Financial Ombudsman Service about his trauma claim with CommInsure.
That's correct, yes.
And you've exhibited a copy of the notification of the complaint to your statement as Exhibit 20, CBA 0001 0508 0094. Now, at the bottom of that page, if we could have the dispute summary, which is right at the bottom of the page enlarged, we see the dispute summary provided to FOS by the insured was trauma claim for heart attack. At the time of heart attack, I was given option of triple bypass or stents whilst on the operating table. The stents ended up being done on 3 separate occasions within 2 months of heart attack. Public hospital evidently did not do a specific type of troponin blood test, so available readings apparently did not meet CommInsure's definition of heart attack, despite plenty of, if we could go over the page, despite plenty of doctor file notes to the contrary, resulted in only a partial trauma claim being paid. I have misplaced my copy of the complaint letter and their response. So that was the summary of the complaint put forward by the insured in FOS.
That's correct.
And the FOS complaint was also handled by Group Customer Relations in CBA, is that right?
Yes.
And with input from CommInsure?
Yes, they did ask, get the claim file from us, yes.
Was that the only input from CommInsure?
No, they also asked for medical advice.
Yes. You tell us in your statement that a customer resolution manager, that's someone from Group Customer Relations, is that right?
That's right.
Spoke to the insured about his complaint. This is paragraph 75 of your statement.
Yes.
And the insured had seen the media reports about the heart attack definition and he wanted his claim reconsidered.
Yes.
And the customer resolution manager asked the CommInsure quality assurance team to review the claim.
Yes.
And they referred it to another internal medical officer, Dr. Carolyn Darby, for her opinion on whether the insured met the new, updated heart attack definition.
That's right.
Now, she was not able to say whether he met the updated definition without further information.
That's right.
So the customer resolution manager asked for more information from the insured.
Yes.
But he also told him that the updated heart attack definition didn't apply to his claim because his claim was made in January 2014 and the new definition only applied from the 11th of May 2014.
That's right.
So wasn't this likely to confuse the insured or raise his hopes? Because on the one hand, he was being told that the new updated definition didn't apply to him, but on the other hand, he was being asked to provide information for consideration by the medical officer.
Yes.
You accept that that was likely to cause confusion
Yes.
and to raise the hopes of the insured?
Yes.
And then in early April, the customer resolution manager discussed the claim with Dr. Carlos, the original medical officer.
Yes.
And the following day, Dr. Carlos gave an opinion in writing, and you've exhibited a copy of that opinion to your statement. It's Exhibit 26, CBA 0001 0508 0475. We see an email there from Dr. Carlos to a person in Group Customer Relations. He says at the top, I have reviewed the medical evidence relating to a trauma claim summarised as follows. He then sets out the evidence And towards the bottom of the page, he said, you verbally requested a point-by-point assessment of this claim under TCP 08-2013 definition of heart attack. So is that a reference to the 2013 definition in the annexure to your statement, which was in place at the time of the claim?
Yes.
And over the page at 0476, we see a table with his point-by-point breakdown. And underneath that table, we see Dr. Carlos says, overall, the condition did not meet this definition.
Yes.
And then he says, you also asked that I comment on whether the following heart attack definition would be met. And he then set out another definition. Is that the updated definition introduced from March 2016?
Yes.
And underneath that definition, he set out his reasoning. He says, there was death of part of the heart muscle, myocardium, as a result of inadequate blood supply to the relevant area confirmed by a cardiologist. The death was evidenced by a typical rise and or fall of cardiac biomarkers with at least one value above the 99th percentile of the upper reference limit, assuming the intended meaning of the latter phrase is that there was at least one value above the 99th percentile of the relevant reference range. The cardiac biomarkers thus elevated were troponin I and CK. There were signs and symptoms of ischemia, I apologise if I've pronounced that incorrectly, consistent with a myocardial infarction. Overall, the condition does meet this definition.
Yes.
So the insured did meet the updated definition,
Yes.
but that definition only applied to claims made after the 11th of May 2014,
Yes.
and his claim had been made 3 months before that time in January 2014.
That's correct.
And having received this opinion from Dr. Carlos, the Customer Resolution Officer suggested to his superior that consideration should be given to making an ex gratia payment because the claim was only a few months before the definition.
That's correct.
But no ex gratia payment was made.
That's right.
Why not?
At the time, the consideration was the claim didn't meet the definition at the time and it wasn't considered appropriate for ex gratia.
Despite this claimant missing out on the new definition by 3 months and falling very short of the 2.0 micrograms of troponin required in the current definition because he'd got to 1.9 micrograms of troponin.
So there's two elements in that. On the first element, yes, you're right. On the second element, if I interpret the 1.9 a little bit differently, if I could explain, and I think it's referred to in the exhibit that you've got shown. The way it's been explained to me is the actual rise in troponin due to the heart attack is the lower number. The number that goes to 1.9 is due to the angioplasty, and so therefore it doesn't meet the definition. So the characterisation of it just being below 2 is not what I understand. But your original question in terms of the 3 months, that is correct.
You accept the first proposition,
Yes.
but not the second
Yes.
in my question. I understand. Now, could I ask that you look at Exhibit 27 to your statement, CBA 0001 0508 0118. So a few days after Dr. Carlos gave this medical opinion, the Customer Resolution Officer provided CommInsure's response to the insured's complaint to FOS. And this is the email that the Customer Resolution Officer sent to FOS.
Yes.
Now, at 0119, he told FOS towards the bottom of the page that it was still CommInsure's position that the insured did not meet the 2013 definition of heart attack.
That's right.
And in the first page, 0118, we see towards the top of the page that he requested that FOS not progress the dispute because the question in dispute was whether CommInsure would pay the claim outside of the policy terms.
Yes.
And therefore, he wanted to invoke FOS's discretion under clause 5.2a of its terms of reference not to progress the dispute on the basis that it related to a matter of commercial judgment for CommInsure.
That's right.
And FOS rejected that challenge to their jurisdiction.
Yes, they did.
And they
Appropriately.
sent CommInsure a letter saying that they would proceed with the dispute.
That's right.
Is it standard practice for CBA to look for ways to challenge FOS's jurisdiction when a customer makes a complaint to FOS?
I don't believe so.
Do you know why it was done in this instance?
No.
And then a few weeks after the letter from FOS advising that it would be proceeding with the complaint, on the 6th of May, the FOS case manager who was responsible for the dispute sent a letter to CommInsure, which you've annexed as Exhibit 31. That's CBA 0517 0208 1914. And we see from the first page of this letter that the FOS case manager set out her understanding of the dispute.
Yes.
And then if we turn to 1916, the third page of the letter, we can see a discussion of the updated medical definition. We see that the case manager said at the top of the page, CommInsure has recently announced on its website the following change of definition of heart attack for its life and loan protection policies to take effect for new events commencing 11 May 2014. And she then set out the definition, and further down the page, underneath the hyperlink, she said, the insured's heart attack occurred in January 2014, which predates the stated commencement date of the May 2014 policy definition as announced by CommInsure. Under paragraph 8.2 of our terms of reference, when deciding a dispute and whether a remedy should be provided, FOS will do what in its opinion is fair in all the circumstances, having regard to each of the following: legal principles, applicable industry codes or guidance, good industry practice, and previous relevant decisions of FOS. In accordance with paragraph 8.2, we advise that we will be reviewing whether the facts of the insured's dispute should also be considered under the May 2014 definition. And then over the page at 1917, the case manager asked CommInsure to provide certain supporting information. And at point 3 in that list, she said, in your response dated the 11th of April 2016, you referred to a medical opinion by CommInsure's Chief Medical Officer against the 2013 policy definition. Please provide a copy of this opinion and any other opinions relevant to this dispute. And at point 4, she said, please obtain and provide a statement from CommInsure's Chief Medical Officer in which he conducts a review and provides an opinion of the insured's medical circumstances against the May 2014 policy definition. Now, at that time, Dr. Carlos had already provided an opinion about whether the insured met the May 2014 definition, hadn't he?
That's correct.
Now, is it fair to say that the receipt of this letter was a matter of some concern within CommInsure?
Yes.
The customer resolutions manager thought it was highly illogical and unreasonable, the position that FOS was taking, and potentially posed a systemic issue for CommInsure.
Yes.
And his boss, the head of priority customer resolutions and quality, thought it was very challenging for FOS to have taken this approach and that CMLA should push back on this approach.
Yes.
Now, on the 19th of May, after consulting within group customer relations, the customer resolution manager responded to this letter from FOS and you've annexed that response as Exhibit 32 to your statement, CBA 0001 0508 0179. Before we go to that, can you explain, Ms. Troup, what the matter of concern was created by FOS's approach to the handling of this dispute?
I believe the matter of concern was FOS determining what the terms of the contract were.
Is that how you interpret the request that FOS made for the information contained in the medical opinions and its indication that it wanted to assess whether the insured met the May 2014 definition?
Yeah, I would express it as an interpretation that FOS were looking to decide when the heart attack definition should apply.
And CommInsure was unhappy with that?
Yes.
And why?
Because I guess a tenement of our policies are the contract. And so if FOS could determine when to apply a definition from, that would make it fairly challenging for us to run our business.
I see. So in this communication that we have on the screen now, on the 19th of May, under the heading Medical Opinion Relating to the Claim, the Customer Resolution Officer responded to the request for the medical officer's opinions. He said at point 5, I have enclosed our medical officer's review of the claim under the heart attack definition, which applied from policy commencement until 10 May 2014, so under the old definition. We decline your request to obtain or provide a medical report to assess whether the applicant would satisfy the upgraded definition of heart attack. The insured suffered the heart attack in January 2014 and has been assessed under the policy terms which applied at that time. And there was a document enclosed with this email that was being referred to in these paragraphs as the second document. It's the second document within the exhibit. If we go to CBA 0001 0508 0195, we see that the document annexed to the email that Group Customer Relations sent to FOS was a copy of the email that Dr. Carlos had sent to that Customer Resolution Officer in April containing his medical opinions. We looked at that email before, you'll recall.
Yes, we did, yes.
You'll recall that the first page had Dr. Carlos's summary of the history of the matter and part of the table with the point-by-point assessment of the claim under the old definition. And then if we go over the page to 0196, we see over the page Dr. Carlos's conclusion that the insured did not meet the 2013 definition, and then the remainder of the medical opinion was redacted.
That's right.
This is the form in which it was provided to FOS.
Yes.
So if we bring up side by side CBA 0001 0508 0475 at 0476 next to this page, we can see that the part of the medical opinion that was redacted was Dr. Carlos's opinion that the insured did meet the updated definition of heart attack. That was blacked out in the version of the medical opinion that was provided to FOS.
That's right.
All right. I want to ask you a series of questions about why that occurred, Ms. Troup, but perhaps that's an appropriate time to break, Commissioner.
We come back at 2:15.
Thank you, Commissioner.
2:15. Yes, Ms Orr.
Ms Troup, I want to take you back to the email that we were looking at before lunch, the email from the Group Customer Relations Officer to FOS, which is CBA 0001 0508 0179. Now, I had shown you before lunch the attachment to this email, which was the medical opinion of Dr. Carlis, with the part of the medical opinion that related to the updated definition blacked out.
Yes.
You recall that?
Yes, I do.
Now, if we return to the email that annexed that medical opinion and look again at paragraph 6, we can see that the explanation given by the Customer Resolution Officer was, we decline your request to obtain or provide a medical report to assess whether the applicant would satisfy the upgraded definition of heart attack. Now, do you accept that that sentence conveyed that CommInsure did not already have a medical opinion about whether the insured met the updated definition?
Yes.
When CommInsure did in fact have that opinion and it was favourable to the insured.
That's right.
But a decision was made to redact that part of the medical opinion from the version that was provided to FOS.
That's right.
And this email to FOS was misleading, was it not?
Unfortunately, yes.
So by sending this email, the Group Customer Relations Officer misled the Financial Ombudsman Service into thinking that CommInsure did not have a medical report on whether the insured would satisfy the updated heart attack definition. You accept that?
Yes.
Was that acceptable, Ms Troup?
Absolutely not.
Why did it occur?
That's a difficult question to answer. I think the intent was they didn't feel that definition was relevant to the assessment, but it's not a decision I would have made.
Well, the assessment of relevance was not one for the Group Customer Relations Officer to make, was it?
I agree.
Now, the same email again included a challenge by CommInsure to FOS's jurisdiction to entertain the dispute.
Yes.
And again, there was a suggestion that this dispute was outside FOS's jurisdiction to consider whether or not the insured met the updated definition.
That's right.
Why did CMLA or CommInsure persist with its argument that the dispute was outside FOS's jurisdiction when FOS had already considered and rejected that argument?
I understand from the review of the documents that FOS had replied refuting the jurisdiction, but this particular team member hadn't seen that. So I think there might have been a gap in understanding, and so they were continuing to pursue their original position.
And how could it be that the Group Customer Relations Officer handling the communications with FOS could not have seen an important piece of correspondence with FOS from that earlier time?
The way it's been explained to me is the email had come in while the person was on leave and it hadn't been registered into their case management system until later.
Should it have been?
Absolutely, yes.
Yes.
That was another mistake.
So that's another part of this communication with FOS that was regrettable?
Yes.
Yes. And do you accept that CMLA should not have persisted with its challenge to FOS's jurisdiction to consider this dispute?
Yes, not in the way that they did there. No, that shouldn't have happened.
Well, once FOS had determined
That's right.
that point, CMLA should have accepted that determination?
That's right.
Yes. Now, a couple of months after this email, on the 29th of July, FOS wrote to CMLA again, and you provide that letter as Exhibit 33 to your witness statement, CBA 0001 0508 0357. And we see from this communication that FOS provided CMLA with further information that it had received from the insured, and it asked for CMLA's comment on that information. You
Yes.
see that?
Yes.
And FOS also asked for an unredacted copy of the medical opinion of Dr. Carlis, or an explanation of the basis for the redaction. Do you see that down at the bottom of the page?
Yes, I do.
And over the page at 0358, FOS also asked for information towards the bottom of the page about how CMLA's heart attack definition compared to the state of medical practice in August 2013.
Yes.
And FOS asked CMLA in this letter how CMLA's heart attack definition compared to other insurers' definitions of heart attack at that time.
Yes.
And over the page at 0359, we see that FOS also wanted to know how CommInsure justified its decision to backdate the definition to May 2014 rather than to August 2013 or an even earlier date.
Yes.
Now, this request for information from FOS caused further concern within CommInsure.
Yes.
What was the concern this time?
It would be the same concern in terms of the contract terms.
So at this time, CommInsure decided to put together a working group to develop a response to this request for information.
Yes.
And to refute FOS's position on these matters.
On those last matters, yes, in terms of the definition, yes.
So CommInsure was concerned that FOS would look into the appropriateness of its decision not to update the heart attack definition in the 3 years between 2013 and 2016, as well as the decision only to backdate to May 2014.
Yes.
Do you agree with that?
Yes.
So rather than responding to FOS's request for information, the group customer relations team decided to enter into some discussions with FOS
Yes.
and to try and convince them to change their approach.
I think to explain the concerns, yes.
On the 9th of August, there was a meeting between representatives of group customer relations and the lead ombudsman and another senior representative of FOS, and in that meeting, the challenge to FOS's jurisdiction was again made.
Yes.
Was that an appropriate thing for CMLA to have done in that meeting, Ms. Troup?
No.
So you agree that your evidence earlier was that that position should not have been a position that CMLA persisted with after the first determination of the issue by FOS?
Yes.
And why was the challenge to jurisdiction made in this meeting on the 9th of August?
Because the team had continued to support their original decision, or their original position.
But was it known by the people who participated in the 9th of August meeting that a challenge to jurisdiction had been made and determined by FOS?
Actually, I'm not sure when that reply from FOS was acknowledged. Apologies, I'm not sure of the time frame.
But we saw it was sometime earlier in the chronology that FOS determined that it was rejecting the challenge to its jurisdiction.
Yes, and that document hadn't been observed by the case manager at that time. What I'm unsure of, I'd have to re-look through the files of when they actually acknowledged that.
So it's possible they still didn't know at the time of this meeting, is that?
I'd have to check, sorry.
Okay, so you're unable to say whether they didn't know that FOS had made that determination or whether they knew and decided to persist with the challenge to jurisdiction.
Yes, that's right.
Okay. But FOS wouldn't change its approach after that meeting. Do you agree with that?
Yes.
And after the meeting, FOS sent another letter to CMLA restating the requests for information that it had made in this letter, which is still on the screen.
Yes, it clarified the requirements following that meeting, yes.
Well, it reiterated its request for an unredacted copy of the medical opinion. Do you agree with that?
Yes.
And on the 19th of August 2016, CBA responded to that request for information, and you've given us that response as Exhibit 35 to your statement. CBA 0001 0508 0553. Now, there are some annexures to this email communication. I'm sorry, we've moved to the letter from the 19th of August 2016, which had an annexure, which also appears in your exhibit, which was an unredacted copy of the medical opinion. Is that right?
Yes.
So more than 3 months after FOS had first requested that opinion on the 6th of May, CommInsure provided the opinion in an unredacted form for the first time on the 19th of August.
That's correct.
And if we turn, if we could have on the screen both the first page 0553 and the second page 0554, we see that although CommInsure provided the unredacted medical opinion, instead of responding in detail to FOS's request for information about how CommInsure's heart attack definition compared to the state of medical practice in August 2013 and how it compared to the definitions of heart attack used by other insurers at that time, CBA requested another meeting with FOS to explain its position about those matters.
Yes.
So no information was provided in this letter on either of those matters.
That's right.
And instead of providing an explanation of why CommInsure chose to backdate the definition to May 2014, CommInsure said to FOS in this letter that those questions were not relevant. Do you see that on 0554? We consider these questions are not relevant to the assessment of the insured's claim.
Yes.
Now, Ms Troup, are you familiar with ASIC Regulatory Guide 139?
Yes.
And you know that that's the regulatory guide that deals with ASIC's approval and oversight of external dispute resolution schemes like FOS?
Yes.
Now, if we could bring that document up, it's RCD 0021 0016 0019. So this is Regulatory Guide 139, and if we turn to pages 0043 and 0044, we see that the regulatory guide says at the bottom of the first page and extending to the top of the second page, there is a general presumption that a scheme member does not have the discretion to withhold documents or information from a complainant or disputant of the scheme. We recognise, however, that there may be some limited circumstances where the scheme member might appeal to the scheme to withhold certain information. Now, CommInsure was a scheme member with FOS.
Yes.
And we see that it goes on, the regulatory guide, to say these circumstances, being the circumstances where the scheme member might appeal to withhold certain information, might include where the release of information would endanger a third party or where it would compromise the scheme member's general security measures. You are familiar with these requirements in the ASIC Regulatory Guide?
Yes, I am.
And I assume, and you can tell me if my assumption is incorrect, that the members of the group customer relations team who deal with FOS on a regular basis would also be familiar with the requirements of this regulatory guide. I
would assume so, yes.
Yes, thank you. I tender that document, Commissioner.
ASIC Regulatory Guide, RG 139, Approval and Oversight of External Dispute Resolution Schemes, RCD 0021 0016 0019, Exhibit 6.140.
Now, this general presumption that we've seen in the regulatory guide about not having a discretion to withhold documents is also reflected in FOS's terms of reference. Are you familiar with FOS's terms of reference, Ms Troup?
Yes, I am.
If we could bring up RCD 0021 0017 0001. And turn within that document to 0015. We can, 0015, I'm sorry. We can see clause 7.2 of FOS's terms of reference is entitled Provision of Information by the Parties to the Dispute. FOS may require a party to a dispute to provide to or procure for FOS any information that FOS considers necessary. That party must comply with FOS's request within the timeframe specified by FOS, except where the party satisfies FOS that, if we could go over the page, A, to provide information would breach a duty of confidentiality to a third party, and despite best endeavours, the third party's consent to the disclosure of the information has not been able to be obtained. B, to provide the information would breach a court order or prejudice a current investigation by the police or other law enforcement agency. Or C, the information does not or no longer exists or is not within the party's reasonable possession or control.
Yes.
And again, is my assumption correct that members of Group Customer Relations would be familiar with FOS's terms of reference, including clause 7.2?
Yes.
Now, did CommInsure seek to satisfy FOS of any of the matters described in clause 7.2 when it withheld information about why it had chosen to backdate the heart attack definition only to May 2014?
Sorry, was it? No, we didn't do that. Is that the?
My question was whether CommInsure sought to satisfy FOS of any of these matters.
No.
Why not?
Yeah, I'm not sure.
Well, none of them applied, did they, Ms
That's
Troup?
true. That's true.
They were not capable of being satisfied in this situation.
That's correct.
And did CMLA seek to satisfy FOS of any of these matters when it withheld part of Dr. Carlos's medical opinion?
No,
They were also not capable of being satisfied.
that's correct.
CMLA simply refused to provide the information sought by FOS on the basis that it didn't believe it was relevant. Is that right?
That's right.
And that was not an approach that was permitted either by the ASIC regulatory guide or by FOS's terms of reference.
That is right.
Do you accept that CommInsure failed to be open and transparent in its dealings with FOS?
Yes.
And that it acted inconsistently with Regulatory Guide 139 and FOS's terms of reference?
That's right.
Can you offer any explanation for that, Ms Troup?
My interpretation is it was a misguided attempt to, as you say, they didn't think it was relevant, and that's what they thought was the right, the way to respond. I don't, as I said before, I wouldn't have made that decision myself.
And they made that decision, they thought it was the right approach in circumstances where they understood the requirements of the regulatory guide and the terms of reference.
Yes.
Now, FOS declined CommInsure's request for another meeting, didn't they?
That's right.
And they instead decided to follow their normal processes and issue a recommendation in the dispute.
That's right.
And before I turn to the recommendation, I'll tender the FOS terms of reference, Commissioner.
FOS terms of reference, RCD 0021 0017 0001, Exhibit 6.141.
Now, the recommendation in the dispute, which is the first formal determination phase of a FOS dispute was issued on the 5th of October 2016,
Yes,
and it was in favour of the insured.
that's right.
And CommInsure decided to reject the recommendation,
Yes,
and you've exhibited a copy of the letter rejecting the recommendation to your statement. It's Exhibit 39, CBA 0001 0508 0677. And we see from this letter, which is a 2-page letter, but you may recall that the second page has only the signature of the author, so the content is all on this first page. CommInsure told FOS that it considered that its decision to backdate the upgrade to the heart attack definition to May 2014 was not reviewable by FOS,
that's correct.
and that having regard to all relevant factors, the choice of May 2014 was reasonable.
Yes,
But the letter went on to say, in the second last paragraph on the page, CMLA does acknowledge that as a result of the current recommendation, the insured's expectations have been significantly raised. CMLA also acknowledges that the recommendation in some part arose from assumptions made by FOS in the absence of input from CMLA, and is concerned that the determination process would create further delay and customer dissatisfaction. In consequence, CMLA has decided to offer the insured an amount equal to the sum insured less previous partial payments, strictly on an ex gratia basis.
yes,
So CBA accepted that its handling of this dispute had affected the insured,
yes,
and following some negotiation, CommInsure did settle the matter with the insured on an ex gratia basis.
yes,
Now, a few months after that, in February last year, FOS wrote to CMLA about the dispute.
yes,
And if I could ask that you be shown CBA 0001 0528 0763. This is not an annexure to your statement, Ms Troup. This is a copy of the letter that FOS wrote to CMLA in February last year. And we see from the first page, 0763, that it referred to the resolution of the dispute that involved the insured. And then over the page at 0764, it referred to FOS's request for the medical opinions that we have been discussing. And it described CMLA's conduct in response to that request. You see that there?
yes, I can.
And then on the third page, 0765, under the heading Our View, FOS set out its view of CMLA's conduct in response to its request for information. It said, the CMLA statements misled us to believe that CMLA did not and would not obtain the relevant medical evidence requested. The statements were made despite the fact that CMLA already had that evidence in its possession. And then 2 paragraphs down, in our view, this conduct constitutes a deliberate failure to comply with the requirement in paragraph 7.2 of the FOS Terms of Reference. That was the communication from FOS.
Yes,
And further down the page, at the bottom of the page, we see FOS said, CMLA's conduct had serious consequences. It caused significant delay in the handling of the investigation. It hampered the timely resolution of the matter for the applicant, had the potential to prejudice the outcome of the dispute. And over the page at 766, the top of the page, in all of the circumstances, FOS has formed the view that the conduct referred to in this letter may amount to serious misconduct, as defined in paragraph 11.3 of the FOS Terms of Reference. And FOS sought CommInsure's response within 21 days, including in relation to steps taken to ensure that this conduct hadn't occurred in connection with any other CommInsure dispute and that it would not occur in connection with any future dispute.
Yes.
I tender that letter, Commissioner.
Letter from FOS to CMLA, 14 February 17, CBA 0001 0528 0763, Exhibit 6.142.
Now, a few weeks after that, CMLA responded to that letter, CBA 0001 0528 1300 is a copy of CBA's response. And if we go to the second page of that letter, 1301, we see that CBA emphasised that there had not been a deliberate attempt to mislead FOS.
Yes.
And CBA also disputed the effects of its actions, saying, and if I can take you to the heading consequences of delay.
Yes.
You have commented, third paragraph down, that CMLA's conduct had serious consequences. As the matter was resolved in favour of the insured, we do not agree that any delay prejudiced the final outcome. And it resisted the characterisation of its actions as serious misconduct. We see under the heading in summary, we acknowledge that the process of information gathering and assessment did not run smoothly, and we regret our contribution to this. However, we do not agree that our actions amounted to serious misconduct and have found no evidence to support a conclusion that CMLA intended to deliberately mislead FOS as to the existence of the medical opinion.
Yes.
Did CBA acknowledge anywhere in this letter what it had been told by FOS, which was that FOS had in fact been misled?
No, I don't think we did in that letter, no.
And did it acknowledge anywhere in this letter that it had not complied with its obligation under clause 7.2 of the FOS terms of reference to provide information to FOS when sought?
No, it did not.
Did it acknowledge that it had not been frank and open in its dealings with FOS?
Not as specifically as what you've just said, no.
No, not specifically nor indirectly.
I had a recollection on the first page there was some recognition of that we hadn't provided the right information.
I'll take you back to the first page in case that assists, 1300.
I guess should have dealt with more promptly.
So there was nowhere in this letter where there was any acknowledgement by CBA that it had not been frank and open in its dealings with FOS.
Correct.
Do you stand by this as an appropriate response to FOS's letter to CBA?
No.
What should the letter have said, Ms Troup?
The letter should have acknowledged the mistakes that we made through this complaint.
Those mistakes being?
Well, firstly, the redaction, that first reply was not appropriate. Secondly, the continuing of positioning the jurisdiction, even though that had been already responded to from FOS. And then thirdly, when they asked for more information around our decision around heart attack, we didn't provide that either.
And should it have not acknowledged
Yes.
that CBA had not been frank and open in its dealings with FOS?
Yes.
Yes. I'll tender that letter, Commissioner.
Letter CBA to FOS, 7 March 17, CBA 0001 0528 1300, Exhibit 6.143.
And then on the 17th of March, 10 days later, CBA got a response from FOS, which is CBA 0001 0513 2849. And FOS said, We have reviewed and considered your response. We have formed the view that the response is not persuasive and it does not provide an adequate explanation for the conduct raised in our earlier correspondence. We appreciate you have been engaging with ASIC. Do you see the last paragraph?
Yes.
In its regulatory review of your organisation on issues related to claims handling in life insurance. As a result, we have concluded that it is appropriate to report the matter to ASIC at this stage for its further investigation and action. That was the communication from FOS.
Yes, it was.
I tender that letter, Commissioner.
Letter FOS to CBA 17 March 17, CBA 0001 0513 2849, Exhibit 6.144.
No, I just want to reflect on where we've got to at this point, Ms Troup. Do you accept that the decision to redact the medical opinion that was provided to FOS was a decision that fell below community standards and expectations?
Yes.
As did the decision not to provide an explanation for that redaction when it was sought?
Yes.
You accept that CBA misled FOS by implying that the medical opinion had not already been obtained?
Yes.
And failed to comply with clause 7.2 of FOS's terms of reference by not providing information that was requested by FOS?
That's right.
Do you also accept that CBA's conduct contributed to delay in the resolution of the particular complaint?
Yes.
And you acknowledge that the way that CBA handled this dispute affected its relationship with FOS?
Yes.
How did it affect CBA's relationship with FOS, Ms Troup?
I mean, the first word that comes to mind is trust. The way we behaved would have been very quick. When I put myself in FOS's shoes, would have been we would have been come across as very adversarial, and that's not the relationship that we strive to have with FOS.
Mm-hmm. CBA decided to conduct an audit into its handling of this dispute, didn't it?
Yes, we were very concerned with how this occurred.
Yes. Can I take you to the audit report, which is CBA 0001 0528 2822. Now, the audit report is dated the 10th of July 2017. We see that date at the top of the page.
Yes, thank you.
And on this first page, we can see that the internal audit was engaged to perform an independent, targeted review. This is the paragraph before the heading 1.2, an independent, targeted review of a number of matters raised by FOS. Do you see that?
Yes.
And if we turn to the following page, 2823, we can see the matters that were excluded from the scope of this audit report. Scope exclusions: we have not reviewed any actions taken by Group Customer Relations or CMLA prior to the 9th of March 2016, the date FOS notified CMLA of the dispute. We have not assessed CMLA's process or rationale in determining the effective backdate for the revised heart attack definition. And we have not made an assessment as to whether the conduct constitutes serious misconduct under the FOS terms of reference, a breach of duty of utmost good faith, or whether it should be reported to ASIC as serious misconduct. Now, excluding the first of those matters, why were the second and third of those matters excluded from the scope of the audit?
The primary purpose was to understand the interactions with FOS and not the CommInsure's decision around the heart attack, so that's why the second bullet point was excluded. And the third scope item there was this was going to be input for management to review those, management and legal, because they've got a legal references in there.
Did management consider those matters, Ms Troup?
Yes.
And what conclusions did management reach?
Well, I think as we discussed a few moments ago, well, I know personally, that it was misconduct under FOS's terms of reference. We didn't consider the breach of duty of utmost good faith applied in these circumstances, and the conduct had been reported to ASIC, and so we didn't feel we needed to consider that further.
Can you explain why the conclusion was reached that this was not a breach of the duty of utmost good faith? You said you considered that it didn't apply. Why?
From memory, I think it was because the duty of good faith applied to the insured, not to our interactions with FOS.
So it applies to the insurer, doesn't it?
Yeah, the insurer and the insured, yes. Yes,
but
that relationship.
you took the view that that didn't extend to the interactions of an insurer with an external dispute resolution body.
I think that was the case, yes.
Mm-hmm. Now, if we go further down this page, we can see the heading Review Conclusion. And under that, we see the first paragraph, we have not identified any evidence throughout this review which indicates either group customer relations or CMLA sought to intentionally mislead either FOS or the insured through their actions and written representations. However, we have made a number of key observations on the actions and written representations of CMLA and group customer relations in resolving this dispute. These observations represent process weaknesses and imprecise decisions in the actions of group customer relations and CMLA in resolving the insured's dispute. So again, we see the focus was on whether there was an intention to mislead FOS.
Yes.
But process weaknesses and imprecise decisions were identified.
Yes.
And we see further down the page that they included point 1, that group customer relations internal quality review process was ineffective in identifying ambiguous and contradictory messages in responses to both FOS and the customer.
Yes.
And the decision to redact the medical opinion without providing an explanation for the redaction itself or fully considering FOS's potential interpretation of the redaction was assessed in the audit report to be a poor decision.
Yes.
And over the page at 2824, the audit also found, point 2, in the absence of a prescribed process for uploading key documents to the First Point system, a letter from FOS responding to group customer relations challenge to their jurisdiction was not identified and addressed by group customer relations. This resulted in a prolonged focus on challenging FOS's jurisdiction and not responding to FOS's direct questions. Now, was that the matter that you were referring to earlier, as to documents not having been uploaded to the system, showing that FOS had determined the challenge to its jurisdiction?
That's correct, yes.
I see. And group customer relations escalation of the dispute to CMLA was not done in a timely manner, which resulted in CMLA management not being included in a number of key decisions.
Yes.
Now, the audit report made a number of recommendations to improve CBA's complaint handling processes.
Yes, it did.
All right, thank you. I tender this document, Commissioner.
Internal Audit Report 10 July 18 concerning FOS Dispute Handling Review, CBA 0001 0528 2822, Exhibit 6.145.
And a month or so after this, on the 24th of August last year, ASIC provided its response to the matter that had been referred to it by FOS.
That's right.
And that is ASIC 0066 0001 0241. So this was the letter that ASIC sent to CMLA dealing with the matter of alleged to be serious misconduct that was referred to it by FOS.
Yes.
And if we turn to 0243, we see at paragraph 9 that ASIC said, based on our consideration of the issues, we're of the view that CMLA should have, when requested by letter dated 6 May 2016, provided to FOS a copy of the whole unredacted medical opinion, and that a failure to do so was likely to be contrary to its obligation under clause 7.2 of the FOS Terms of Reference. The provision of the unredacted medical opinion at the relevant time would not have precluded CMLA from making its submission that FOS did not have jurisdiction to consider the dispute. Such submissions were set out in CMLA's email dated the 19th of May 2016. And then in paragraph 10, ASIC said that the wording used in response to the letter from FOS was likely to mislead, as it gives the impression that CMLA did not already have the medical opinion in relation to an assessment of the insured's claim against the updated definition. You see that?
Yes, I do.
And ASIC accepted in paragraph 10 that it had not seen any evidence to indicate that CMLA intended to mislead FOS. However, in the circumstances, the practical effect was that it was likely to, and in fact did, mislead FOS.
Yes.
Having reached those conclusions, what action did ASIC take against CMLA?
The letter went on for recommendations for what they encouraged CMLA to do in response to their findings.
ASIC encouraged you not to do this again
Yes.
and said that they expected you to implement the recommendations from your internal audit report that I had just taken you to.
Yes.
Thank you. I tender this letter, Commissioner.
Letter ASIC to CMLA, 24 August 17, ASIC 0066 0001 0241, Exhibit 6.146.
Did ASIC implement those, did CMLA implement those recommendations, Ms Troup?
Yes, we did.
All right. And what changes has CMLA made as a result of this experience with FOS?
Well, those...
In general terms, if you could explain the changes that have been made.
Yeah, well, I mean, in general terms, it was reinforcing our obligations to be open and transparent across all of our team members. Secondly, there were some very practical implementations there of one of the big learnings from myself is the interaction between us and GCR needed to improve. And I think particularly in those first 2 months, we didn't communicate clearly to GCR and we felt responsible for part of that. So there's an element of ensuring that your communication and training is clear. And then thirdly, there was the sensitivity of these claims and complaints and ensuring the right level of review, the right level of seniority to help people with those judgments. They would be the three that I would call out.
Mm-hmm. Now, while the FOS dispute was going on, ASIC was investigating a number of aspects of CommInsure's life insurance business, wasn't it?
Yes, it was.
And that investigation began shortly after the Four Corners and Fairfax media reports that I referred to earlier.
Yes.
And it took place alongside a broader ASIC inquiry into claims handling practices across the life insurance industry.
Yes.
ASIC looked into the concerns about outdated medical definitions in CommInsure trauma policies.
Yes.
And it also investigated CommInsure's life insurance claims handling practices.
Yes.
And on the 23rd of March 2017, ASIC publicly announced the results of its investigation into CommInsure.
Yes.
And it did this by issuing a media release.
Yes.
And attached to that media release was a summary of ASIC's findings. Do you recall that?
Yes.
Now, could I take you to the media release and the attachment, RCD 0021 0016 0077. This was the media release issued by ASIC.
Yes.
And if I could take you to 0080 in that document. We see the first page of the attachment to that media release.
Yes.
I tender the media release and the attachment, Commissioner.
ASIC Media Release 17-076MR findings of CommInsure investigation, together with its attachment RCD 0021 0016 0077, Exhibit 6.147.
Now, the day before ASIC issued that media release, Peter Kell, the Deputy Chairman of ASIC, sent a letter to the Chairman of CMLA,
Yes?
and that letter is ASIC 0066 0001 1134. Now, this is the letter from Mr Kell to the Chairman of CMLA on the 22nd of March 2017. It was a lengthy letter, but I assume you're familiar with this letter, Ms Troup.
Yes, I am.
And if we turn to the second page, we can see an executive summary of the letter at 1135. Mr Kell says, in this letter we outline our investigation into and our concerns arising from the following issues. And then he sets out a list of issues, some of which I want to come back to. And he then went on to say in paragraph 5, overall, ASIC's investigation has concluded that CMLA has not contravened the law other than in relation to the advertising of trauma cover for events such as heart attack, which is still under investigation. However, there are a number of areas of concern where we expect improvements to be made. Now, I'm not going to address all of the issues dealt with in this letter, but I want to ask you questions about 3 of those issues. And the first is the use of outdated medical definitions. If we stay on this page at 1135, we see that the first issue that was identified by Mr Kell in paragraph 4, we'll need to pan up to subparagraph A, was described as policy terms, including the use of out-of-date medical definitions for terms such as heart attack and severe rheumatoid arthritis in trauma cover. And if we turn to the third page of the letter at 1136, we can see where Mr Kell addressed the topic of policy definitions in this letter. And Mr Kell told the Chairman of CMLA that ASIC had reviewed a range of definitions used in CMLA's life insurance policies that could be separated into medical definitions and TPD definitions. And in paragraph 4, he made clear that ASIC's review did not cover all medical definitions used by CMLA. From the review that we undertook, we are concerned about the use of definitions which have become outdated or are not aligned with current medical practices, such as heart attack of specified severity and severe rheumatoid arthritis, as well as inconsistent outcomes and the potential for consumers to misunderstand the terms of their policies due to the use of confusing and unclear definitions. And over the page, the use of definitions that fell significantly short of consumer expectations. You see that, Ms Troup?
Yes, I do.
Now, in paragraph 15, Mr Kell said, with respect to the use of definitions that have become outdated or are not aligned with current medical practices, ASIC has concluded that CMLA's mere reliance, without more, on outdated definitions as a means of determining whether it has an obligation to pay benefits under the policy is not a breach of the duty of utmost good faith in section 13 of the Insurance Contracts Act. However, ASIC is concerned that this practice falls significantly short of consumer expectations.
Yes.
Now, Mr Kell addressed the heart attack definition in more detail later in this letter. If we go to page 16 of the letter at 1149, we see that under the heading heart attack, he recorded He referred firstly to CMLA announcing a change to the medical definition of heart attack on the 10th of March 2016. And he went on to note at the bottom of that page and over to the following page that in 2012, the European Society of Cardiology, the American College of Cardiology, the American Heart Association and the World Health Federation published an expert consensus document about the definition of heart attacks. You're
Yes.
aware that that happened at that time, Ms. Troup?
Yes.
And that report endorsed the use of troponin as a means of detecting heart attacks.
Yes.
And the report said that laboratories should use a cut-off value of the 99th percentile of a normal reference population to determine whether there had been a heart attack.
Yes.
See that?
Yes, I do.
And he went on to say in paragraph 97 that the decision by CMLA to select the 11th of May 2014 as the effective date of the change does not have a robust rationale, given the joint report was published in 2012 and not 2014. While this is not contrary to the law, it is ASIC's view that this has unfairly impacted on some consumers, and better practice would be to select an earlier date. CMLA's conduct in relation to updating its medical definitions was unreasonably slow in responding to changes in medical practice. CMLA's internal documents demonstrate that CMLA was on notice that the standard was to be updated, and even 3 years after the joint report was published, CMLA had yet to change its definition. We note 7 other insurers had updated their definition by the 11th of May 2014. This was the communication from ASIC to the chairman of CMLA.
Yes, it was.
Now, you told us earlier, I'll tender that letter, Commissioner, and I...
Letter from Mr Kell of ASIC to the Chair of CMLA, 22 March 17, ASIC 0066 0001, 1134, Exhibit 6.148.
You told us earlier, Ms Troup, that CommInsure decided in March 2016 to backdate the updated heart attack definition to May 2014.
Yes.
And after it made that decision, CommInsure conducted a review of its declined heart attack claims going back to May 2014,
That's right.
and it paid claims that would have been allowed under the updated definition.
That's correct.
And in its media release, which I took you to earlier, CommInsure said it chose the 11th of May 2014 because that was the date of the last relevant product disclosure statement.
Yes.
And in your statement to the Commission, you said that CommInsure chose that date because that was the date of the most recent full product review.
Yes.
Are they both different ways of saying the same thing?
Yes.
Was that the only reason why CommInsure chose to backdate the updated definition to May 2014?
It was the primary reason in terms of it was, at the time, a judgment decision on how far to go back, and based on the information given to us in March 2000, let's get the date right, 16, we felt that was the appropriate date at that time.
So you said the primary reason was because that was the date of the most recent full product review. What were the other reasons for choosing that date?
I think it was also the context of when is a reasonable time to implement the updated definition.
Or what led CMLA to believe that May 2014 was a reasonable time?
It was advice from the product team in terms of we considered how many others had moved in the market, our own working documents in terms of when we had considered it previously.
What were the considerations given to how many others had moved in the market?
Sorry, could you ask that again?
You said that one of the things that was considered was how many others had moved in the market.
Yes.
So how was that factored into the decision?
Well, I think it was, relative to, one of the considerations was relative to our competitors and other movements in the market, how many others had moved and not moved.
Or how many had moved and not moved as at 11 May 2014? Do you recall?
No, I mean, you've just reminded me via that letter that ASIC said there were 7 that had, and I think the market has maybe 12 or 14 providers. So a bit over half, I think.
Over half had already moved by that time. And when had they all moved?
At various times from 2012 through to 2014.
So that was a factor in the decision to choose the 11th of May 2014.
Yes.
And where do we see that in the media releases explaining 11 May 2014 as the date that was chosen by CommInsure?
It wasn't in the press release.
Why not?
I guess one of the elements in terms of communication and that the messages, there's only so much messages that you can convey. So we chose with the primary reason was when was the last product update that we should have done it by, and that was May 2014.
Well, was the primary reason, Ms. Troup, that the 11th of May 2014 was in the middle of the range of dates when your competitors had updated their definitions?
As I said, that was one of the reasons, but
Was that the primary reason?
No.
And having decided that date, you were able to link it to a product review?
Yes.
So, did you assess what date put you in the middle of the movements of your competitors?
No, the analysis wasn't done with competitors first find the date. The analysis was done in terms of our product review cycles and when was the last time this should have been done via our normal product review cycle. But the analysis on the market was also done to complement that thinking.
The analysis on the market, what are you referring to there? That's the analysis of the movement of your competitors.
Yes.
It was done to complement the thinking, did you say?
Yes.
Okay. Could I ask that you look at CBA 1004 0003 3949? These are minutes from a meeting of the Board of CMLA on the 9th of March 2016.
Yes.
So that was 2 days after the Four Corners story was broadcast.
Yes.
And the day before, CommInsure announced that it would update its heart attack definition and backdate the updated definition to the 11th of May 2014.
Yes.
And if we turn to 3963 in these minutes, we can see there that there was discussion of the proposal to update the heart attack definition and backdate the updated definition. Do you see the references to that in the top part of that page, in the first and the third dot points?
Yes.
The third dot point said, it is now proposed to apply the new definitions from 11 May 2014, which is the date of the last PDS.
Yes.
And underneath the bullet points, we see that the board asked questions about the appropriateness of the 11th of May 2014 date.
Yes.
Now, you were present at this meeting.
Yes.
But the minutes suggest that you departed the meeting for this discussion. Is that right?
For some of it, yes.
And why did you leave the meeting?
I was dealing with some of the other matters raised in the media that week.
Right, so it wasn't to do with the content of what was being discussed, it was because you needed to leave to deal with other things, is that right?
Yes.
Now, the minutes record here that Dr Phillips answered the board's questions about the appropriateness of the 11th of May 2014 date.
Yes.
And Dr Phillips was the head of Life Product and Strategy, Life Product and Distribution.
Yes.
In response to questions from the board regarding the appropriateness of the 11 May 2014 date, Dr Phillips explained that while the clinical definition of heart attack changed in 2012, this was not immediately adopted, even in medical treatment, and only one competitor updated its definition in 2012 with a partial payment, later moving to a full payment. Many competitors updated their definitions before 11 May 2014, some with partial payments only. The date of 11 May 2014 is in the middle of the range of dates when those competitors who have upgraded their definitions did so. And as the PDS was changed on that date, it is reasonable to adopt that date as the commencement date, being the date on which the company would have upgraded its definition, as adopting another date would be arbitrary. In addition, the benefit paid under the new definition is a more generous benefit than the partial payment, which some competitors provide under the upgraded definition. The decision taken by the company in May 2014 was to adopt a lesser benefit by applying the definition of heart attack of specified severity. We'll just need to go over the page. In order to keep the product price lower for customers. Now, on that page, we see that the board considered the potential financial impacts of the updated definitions and the proposal to backdate them. Do you see that?
Yes, I do.
And the board endorsed the proposed approach.
Yes.
So based on that discussion, I want to suggest to you that a significant factor in the choice of 11 May 2014 as the date to backdate to was that that would put you in the middle of the range of dates when your competitors who'd upgraded their definitions did so.
Yes, it was one factor, yes.
Yes. Was it a significant factor, Ms Troup?
I wouldn't draw that conclusion.
Was it a factor that should have been made known to the public when you were explaining this decision?
Yeah, I would say I hadn't thought of that question prior to now. Again, we decided that the primary reason was the best communication, and there would have been no harm in us explaining that further.
And would there have been any harm in explaining this to FOS when it asked to the resolution?
No. No.
I tender the minutes, Commissioner.
Minutes of CMLA Board Meeting 9 March 16, CBA 1004 003 3949, Exhibit 6.149.
You gave evidence earlier that CommInsure rejected FOS's recommendation in the particular case of the insured, which found that CommInsure had not properly justified its choice of the 11th of May 2014 as the date to which it would backdate the updated definition.
Yes.
But after receiving the letter from Mr Kell, which I took you to earlier, CommInsure decided to change its position and to backdate the revised heart attack definition even further to October 2012. Is that right?
That is correct.
Now, it made that decision, it seems, in 24 hours, in time for it to be included in the media release issued by ASIC the following day. Is that right?
That is correct.
So did CommInsure have advance notice of the position that ASIC was going to take in that letter that was sent to the chairman of CMLA the day before the media release?
ASIC had been communicating with us in I think the week before where their investigation was landing, yes.
And so did it have advance notice of ASIC's position on this topic, on the backdating of the upgraded heart attack definition?
Hard for me to be definitive, but I would assume yes.
It had received an earlier version of the letter sent by Mr Kell on the 22nd of March, is that right?
Yes.
And the board of CMLA met on the date of that letter on the 22nd of March, is that right?
Yes, they did have a meeting that day, yes.
And if we look at CBA 0002 1223 3231, we see an email here from Mr Austin to a number of people within CMLA, including you. Who was Mr Austin? Who is Mr Austin, Ms Troup?
He's the chairman of the CMLA board.
Thank you. And we can see that the chairman of the CMLA board recorded that the board considered that there was a sound rationale now for the selection of May 2014, the original selection,
Yes.
because with the benefit of hindsight, the board believed that a decision to change the definition of heart attack at that time would have been a more appropriate decision, both commercially and in the interests of policyholders.
Yes.
But they accepted that there was no single right perspective or view. Do you see that?
Oh, yes. Yes.
So they authorised management, specifically you and Annabelle Spring, to decide to backdate the updated definition further. Is that right?
Yes.
We see that from the last paragraph on the screen at the moment. So you were authorised by the board with Ms Spring to extend the backdating beyond May 2014.
Yes.
And that happened as a result of a meeting of the board of CMLA following the receipt of the final letter from Mr Kell on the 22nd of May 2017.
Yes.
I'm sorry, the 22nd of March, thank you, 2017. Now, in order to approve backdating the definition further, you needed to get actuarial advice about the cost, didn't you?
Yes.
And that actuarial advice was prepared overnight.
Yes.
And if we go, I'll tender that email first, Commissioner.
Email from Austin to Troup and others, 22 March 17, CBA 0002 1223 3231, Exhibit 6.150.
And if we go to CBA 058501401932, we see a copy of the actuarial advice that you received.
Yes.
Is that right?
Yes.
And then if we go over the page to 1933, we can see a reference to CommInsure's earlier estimates of the cost of introducing the updated definition and backdating it to May 2014. So there'd been some actuarial work done in 2016 about the cost of backdating back to 2014.
That's right. Yes.
And we see that work reproduced in this document. And the bottom table shows that the cost of backdating to May 2014 was originally estimated to be $14.7 million. Do you see that figure in the bottom table under total?
Yes.
With a possible range of $7.3 million to $22 million.
Yes.
But if we go to the next page, 1934, we can see that the actual cost of that decision to backdate to May 2014 ended up being much smaller. It was, and we might need to pan down just a bit, it was $2.5 million.
Yes.
So it was well below the estimated cost of backdating to May 2014.
Yes.
And was that one of the reasons why CommInsure was able to decide so quickly after receiving ASIC's final letter to backdate the definition further to October 2012?
Yes.
Because you had budgeted up to $22 million for the cost that you would incur as a result of that backdating, and you had incurred only $2.5 million of that possible $22 million.
Yes.
I tender the Actuary's report, Commissioner.
LPS 320 report for further backdating of heart attack definition 23 March 17, CBA 0585 0140 1932, Exhibit 6.151.
Now, having received that report from the Actuary, you and Annabelle Spring made the decision to backdate the updated definition to October 2012.
Yes.
And do you believe that October 2012 was a more appropriate date to take that updated definition back to?
Yes.
Now, do you believe that CommInsure should have backdated to that date in 2016?
Sitting here today, yes.
So the day after the work of the Actuary overnight and the decision that you and Annabelle Spring made as a result of the work of the Actuary or facilitated by the work of the Actuary, ASIC put out its media release on the 23rd of March. And that media release announced that CommInsure had agreed to backdate the heart attack definition to October 2012.
Yes, it did.
Yes, so you had conveyed to ASIC that decision in time for it to be incorporated into ASIC's media release.
Yes.
How was it conveyed?
Over the telephone.
By who?
By me.
To who?
Michael Sadat.
Yes, and when did that occur?
The night before.
Could I ask that you look at CBA 0585 0140 3517? This is an email chain from the 23rd of March 2017, the day of the media release, and we see that that afternoon Andrew Hall, do you see his name about halfway down the page?
Yes, I do.
Who was from Corporate Affairs at CBA, is that right?
That is correct. Andrew
Hall sent out an email about ASIC's report and the media release.
Yes, he did.
And we see that that email was forwarded to you by Clive Van Horen within CBA, who said, "Hi, you must be very happy with this, a strong set of findings from ASIC."
Yes.
That was the communication you received from Mr Van Horen.
Yes, it was.
Were you happy with the set of findings from ASIC?
Yes, I was.
And what were you happy about with those findings?
As you've alluded to, there were some extremely serious allegations made against CommInsure on the Four Corners program, and they were found to be unsubstantiated, and that was a very good outcome for CommInsure.
Well, you say they were found to be unsubstantiated. The findings of ASIC were that there had been no contraventions of the law, but that in many respects the practices of CommInsure were a matter of concern. Do you agree with that?
There were other areas of concern, yes, but when it came to the, if I may explain.
Yes, please.
The heart of the allegation goes to the heart of a life insurance company, you know, in terms of that. The accusation was we were denying claims and mistreating our customers. Out of all the allegations, that's the one that caused me the most concern for myself, my people, my customers. And so for that to be unsubstantiated was quite significant for us.
I understand. And you responded to Mr Van Horen Thanks, Clive. Sorry I was a no-show last night, was working with ASIC until 10 p.m. If only I could get the same outcome for CCP. That was the credit card protection insurance product that was the subject of a case study in the first round of hearings.
Yes.
Now, you were working with ASIC until 10 p.m. What was that a reference to?
To the finalising of our position on the backdating of heart attack.
So what did your work with ASIC involve?
So it was just clarifying what ASIC's request was and also confirming the process for what we would use to backdate that definition and find customers that would need to be paid.
And those clarifications and those discussions were held between you and Mr Sadat from ASIC, is that right?
I believe that's right, yes.
All right. I tend to the email chain, Commissioner.
Emails concerning CommInsure ASIC update of 23 March 17, CBA 0585 0140 3517, Exhibit 6.152.
So having made that decision to backdate the updated heart attack definition to October 2012, CommInsure then reviewed its declined heart attack claims going back to that date,
That's right.
and it paid claims that would have been allowed under the updated definition.
Yes.
And following that review, there was a closure report prepared on the backdating issue.
Yes.
And that is ASIC 0066 0005 0011. Now, if we turn to 0015 of this report, we can see a summary of the outcome of the first of two phases encompassed by this work that was being done. Is that right? There were two distinct phases to the work?
Yes, so the 2014 backdate and then the 2012
I
backdate,
see.
yes.
So the first phase of the review related to the backdating to 2014.
That's correct.
And if we turn to 0015, we can see a summary of the outcome of that phase of the review in the first table that appears on that page. And that review included cases of severe rheumatoid arthritis as well as heart attacks. Is that right?
That's right.
And of the 165 possibly relevant claims identified, 119 were determined to be out of scope.
That's correct.
And of the remaining cases, 23 were found not to meet the new definition.
That's correct.
But 17 heart attack claims that were denied under the old definition were found to meet the updated definition.
Yes.
And on the previous page, 0014, we can see the results of the second phase of the review. So that was taking it back to October 2012, is that right?
Yes, phase 2 was 2012.
And that only related to heart attack cases, is
That's
that right?
Yes.
And of the 171 possibly relevant claims identified, 146 were determined to be out of scope.
That's correct.
And of the remaining cases, 9 were found not to meet the definition.
Yes.
But a further 16 heart attack claims that were denied under the old definition were found to meet the updated definition.
Yes.
And that included the case of the insured person that we were discussing earlier in the day.
Actually, his case wouldn't be there because he'd been paid earlier.
Right, so he
So-
wasn't included in those numbers.
No, because he'd already been.
He'd
paid.
already been given an ex gratia payment.
That's correct.
Now, if we turn back to 0015, we can see that there were a total, this is the second table, a total of 34 heart attack claims that were denied under the old definition that were found to meet the updated definition once we went all the way back to 2012. Is that right?
Sorry, did you say 34 or 33? The heart attack is 33. The 34 includes the...
I'm sorry, you're right.
Yeah.
33 heart attacks.
Yes.
And 34 included the one case of severe rheumatoid
Arthritis.
arthritis. Thank
Yes.
you.
Yes.
Now, the 33 heart attack claims that were denied under the old definition and met the updated definition resulted in CommInsure paying $4.257 million in relation to those claims.
That's correct.
So a significant amount of money was paid to 33 claimants as a result of that decision to backdate to October 2012.
Yes.
Now, you accept, I think your evidence is clear, that you accept that CommInsure ought to have updated the heart attack definition and backdated it to 2012.
Yes, based on everything I know today, yes.
Should it have just updated the heart attack definition in the first place in 2012?
Yes.
And do you accept that the decision not to update the heart attack definition at that time fell below community standards and expectations?
Yes, I do.
Were there any remuneration consequences for anyone at CommInsure arising from all of this?
I don't believe so, no.
Were there any remuneration consequences for you?
Not in the specifics of heart attack, but as a result of the investigations in CommInsure, there was an impact, yes.
And what was that impact?
The board, in terms of our yearly STI process, for want of a better
A
word.
short-term incentive, yes.
Thank you. The payment that was due in the middle of the investigation, a proportion of that was held back until the results of the investigations were concluded.
So a proportion of your incentive payment was held back until the investigation was complete?
Yes.
What proportion?
I think it was I'm going to say a third. I would probably prefer to check that detail, but I think it was around a third.
And what happened on the completion of the investigation?
That was vested to myself, yes.
So the short-term incentive payment was delayed,
Yes.
but was still paid to you, is that right?
Yeah, once the investigation was completed, yes, it was.
I see. Now, in your statement to the Commission, you describe CommInsure's decision not to update its heart attack definition in 2014 as a commercial misjudgment.
Yes.
Yes. And do you accept that the decision not to update it in 2014 was also a decision that fell below community standards and expectations?
Yes.
Thank you. And we see the consequences of those decisions when we look at these figures that demonstrate the number of people whose claims would have succeeded if the updated definition had been made at either of those 2 points in time.
That is correct.
Thank
Yes.
you. I tender, Commissioner, the further backdating of heart attack definition closure report dated the 5th of June 2018.
ASIC dot 006600050011 becomes Exhibit 6.153.
I want to take you in just a little bit of detail to the reasons why CommInsure decided not to update the definition at those earlier points in time, Ms. Troup. Can you explain firstly just the general process for updating medical definitions in CommInsure trauma policies that applied between 2011 and 2014?
So, I think you understand I wasn't in the organisation at that time. So based on my reading of the policies and processes, an update to a medical definition is similar to the process for just generally updating a product in terms of we have what's two frameworks around our product development process, a group framework and a CMLA framework that works us through ID, the beginning of a project, so what ideas are people considering, then they're assessed in terms of pricing, actuarial, competitiveness, research, etc. Then they're sought for approval and then they move to implementation. Is that what you were looking for in that question? Yep.
As I understand it from the documents, the process took place in product development cycles, is that right?
Yeah, that would be one of the expressions we would use, yes.
And roughly how often would each medical definition be reviewed?
At that time, it would depend. It would depend on. So, I guess there's two phases. Every year there is an annual product review where a product is assessed across a range of criteria, and so that would be an opportunity for any medical definition to be reviewed. Second to that, we have research teams that can highlight at any time changes in the market, changes from doctors, changes that need to be considered, and that can come from any area. Feedback can come from our doctors, our customers, etc. And so you can initiate a review out of those other cycles, the predictable annual cycle.
So we saw earlier that the definition of heart attack in the trauma policies was unchanged between July 2005 and March 2016.
Yes.
But there were times in that 11-year period when CommInsure considered updating the medical definition and decided not to.
That's correct, yes.
And I want to ask you about some of those decisions, but before I do that, I just want to put some propositions to you about developments in the way that heart attacks were detected over that period. Now, as I understand it, troponin is a protein found in heart cells. You referred to it as an enzyme, I think, before.
I think you're right. I think it is a protein.
And that measurements of troponin can be used in the diagnosis of heart attacks.
Yes.
And are you aware that in 2007, a task force convened by the European Society of Cardiology, the American College of Cardiology, the American Heart Association, and the World Heart Federation published a paper setting out a universal definition of myocardial infarction or heart attack.
Yes.
And there had been an earlier consensus definition of heart attack in 2000, is that right?
I think you're right, yes.
Mm-hmm. But between 2000 and 2007, newer, more sensitive methods for detecting heart attacks were developed.
That's right, yes.
And in 2007, the task force updated the consensus definition to reflect those developments.
I guess the timing sounds right, yes, from memory, yes.
And their paper said that the preferred way to determine whether there'd been a heart attack was by measuring troponin levels.
Yes.
And that laboratories should use a cut-off value of the 99th percentile of a normal reference population to determine whether there had been a heart attack.
Yes.
And this was because different assays or tests for the level of troponin had different levels of sensitivity. Am I right?
I think you are. You're doing
Thank you.
very well.
And the 99th percentile would be different depending on the type of equipment that was used to measure.
Yeah, that's my understanding, yes.
Now, in 2012, the same task force published another update to the universal definition of heart attack.
Yes.
And they again endorsed the use of troponin to detect heart attacks.
Yes.
And the use of the 99th percentile of a normal reference population.
Yes.
And the task force recommended that different reference values be used for men and women.
Yes.
But CommInsure's heart attack definition at the time didn't make reference to the 99th percentile of a normal reference population.
That's right.
Instead, the CommInsure heart attack definition required an elevation of troponin I levels that had to exceed that 2.0 micrograms per litre measure.
Yes.
Regardless of the sensitivity of the testing that was done.
Yes.
And regardless of whether the insured was male or female.
Yes.
And they also had to meet certain other requirements in the definition.
Yes, most heart attack definitions have a two-tier element.
And do you accept that within CommInsure, it was known from at least early 2012 that CommInsure's definition of heart attack didn't reflect the universal definition of heart attack?
Yes.
there had been a proposal, had there not, in September 2011 to update the definition of heart attack in the next product development cycle.
Yes.
And as part of that change, it was proposed that the requirement that troponin I levels exceed 2 micrograms per litre be replaced with a requirement that they exceed the 99th percentile.
Yes,
But that proposal was not adopted.
that's correct, yes.
Why not? Do you know?
I mean, I have looked through the documents. Yeah, I think it was a combination of factors. You know, they were working through what the appropriate measures were and pricing and things like that. But it wasn't well documented, the decision why not at that time
So it's
that I could see.
not well documented, so you're not able to say why that decision was made, but you mentioned pricing as one of the factors.
I will in preparing for today, I've probably looked at a few of those documents through that period, and so I'm just hesitant to put which one was at which date.
Well, perhaps I can show you a document to assist with that. Well, as it turns out, I can't put a document to you to assist with this because we've been unable to find a document that explains that decision, and you're unable to assist with that.
That's right.
Okay. So that was September 2011. There was a proposal to change the definition at that time. And then in February 2012, there was another product design description prepared, which noted that current movements within the industry are leaving CommInsure behind, especially in regard to the heart attack definition. Do you recall seeing that?
Yes, I do.
So that was February 2012, that internally there was discussion of CommInsure being left behind in relation to its heart attack definition. And then in March and April 2012, there were internal meetings to discuss a potential review of the heart attack definition.
Yes.
And one of those meetings was on the 27th of March 2012. Could I ask that you look at CBA 0001 0526 0592. So this is an email from Glenn Aarons, who appears to have been a product manager with retail advice products, to a number of other people in CommInsure, including Dr. Carlis, the medical officer involved in the claim by the insured person who we spoke of earlier. And it deals with a meeting that was held earlier that day on the 27th of March 2012.
Yes, although I don't see Dr. Carlis. I see Dr. Monday, but was it mentioned in the document?
I'm sorry, that may be my mistake. Let's not. So I'll withdraw that. Yes. The reference to Dr. Carlis. You're right to point out that his name doesn't appear in the email recipients at the top of the page. But do you accept that this email records discussion and action points that came out of a meeting that had been held on this date, the 27th of March 2012?
Yes, I do.
And Mr. Aaron says earlier discussions were focused on moving to a severity-based definition. Do you see that reference? First dot point under below are the discussion and action points.
Yes, I do.
What do you interpret that to mean?
I've interpreted that to mean, I think earlier we talked some responses were to pay a partial benefit rather than a full benefit. So often we use the term severity to graduate the payment based on the severity of an illness. So that's how I've interpreted. They were debating partial versus full payments.
So was one of the possibilities making clear that the policy would only cover severe heart attacks, or was it about it covered all heart attacks but only a partial payment of the benefit amount?
So it would pay a full payment for severe heart attacks.
Yes.
And a partial payment for less
severe heart attacks. So
because
that-
the new troponine was picking up smaller and smaller heart attacks, and so trying to get that risk balance with the coverage of the policy, I think, is what they were.
So that was
considering.
one of the ideas that was being discussed. But Mr Aarons goes on to say, however, current movements within the industry and the downgrading of our heart attack definition has forced us to reconsider that direction and to consider current market-leading, I would say, definitions with some exclusions around other heart attacks.
Yes, I see that.
What do you understand Mr Aarons to be referring to when he talks about downgrading of our heart attack definition?
I think he's referring to the concept of research houses, the service provided to the retail market that grade our products and our definitions. And I'm not sure of the timing, but heart attack was a definition that was rated in research houses. And as people, as a company enhanced their definition, they would get an A and other companies would drop to a B.
And is the rating level A, B or C, is that right?
It would depend on, there was more than one research house. Some research houses uses numbers, but yes, ABC was the one that I've seen through the documents preparing for today.
And Mr Aarons went on to say in the third dot point, using the 99th percentile aligns us with current AMA and European medical definitions. So by March 2012, it was understood within CommInsure that its heart attack definition did not reflect current medical definitions.
Yes.
And underneath this, under the heading possible pricing concerns, there's a reference to possible RGA resistance with passing back new definition. Now, RGA was the reinsurer for the trauma policy, is that right?
That is correct.
And we see also from under that heading that actuarial advice was sought on the pricing impact of changing the definition.
Yes.
And then further down under the heading action points, we see that one of the things to be followed up was stats on current declined rates if using the 99th percentile definition.
Yes.
And another was make contact with RGA to start talks and gather their thoughts on all of the above.
Yes.
What's the role of a reinsurer in decisions about updating medical definitions or changing policy terms?
Well, they're a party to the coverage, and so therefore if you've got a reinsurance arrangement, they must approve your product changes for it to continue to be covered.
I'll tender that email, Commissioner.
Email concerning trauma definition, heart attack, minutes 27 March 2012, is it?
Yes, it is, Commissioner.
CBA 001052605992, Exhibit 6.154.
And could I ask you now to look at some emails from about a fortnight later on the 11th of April 2012, CBA 001005280247. Now, we see that following the meeting on the 27th of March, I want to make sure I get this date right. Sorry, just excuse me for a moment, please. It's the first email at the top of the page that I want to direct you to. So that's an email from William Munday. Now, at that time, Dr. Munday was CommInsure's Chief Medical Officer.
Yes, he was.
And I'm sorry, I'm confusing myself here. Can we start with the email on the bottom of the page, which is an email from Lisa Nistroy to Mr. Munday, who was the Chief Medical Officer at the time.
Yes.
Who was Ms. Nistroy?
She worked in the product team.
Okay. And Ms. Nistroy says to CommInsure's Chief Medical Officer in this email on the 11th of April, so about a fortnight after the meeting, we've had another interesting conversation around possible changes to our heart attack definition. Our resident expert, Dr. Carlos, is keen to see a shift to align with the universal definition of a heart attack. And she then set out the definition. And if we go over the page to 0248, we see right down the bottom of what's on the screen at the moment, we have been talking, about halfway through that email, can you see that bit, Ms. Troup? We have been talking about a change.
Yes, thank you.
We have been talking about a change in definition for some time before a shift in the market started to occur in response to some contentious claims, i.e. clients not meeting our definition and therefore being declined for heart attack, though medically they were diagnosed as having had a heart attack. So
Yes.
by April 2012, it was recognised within CommInsure that there were cases where CommInsure customers were being diagnosed by medical practitioners as having had a heart attack, but their claims were being denied because they did not meet CommInsure's definition.
That is correct.
And Ms Nestroy outlined 4 options for how CommInsure could proceed. The first was leave the current definition, however relabel to indicate heart attack of a particular severity level. That was the idea that we discussed earlier.
Yes.
2, change our standard heart attack definition in line with the universal definition and recent market changes with the PCI exclusion. Do you know what that's a reference to?
No, it's
No.
it's an abbreviation of another condition of the heart, but
It was further up the page.
yeah,
Sorry.
I can't.
Percutaneous coronary interventions. Thank you, Commissioner.
Yes, thank you. I'll let you both have that one.
3, change our standard heart attack definition in line with universal definition with no exclusion for percutaneous coronary interventions. Or 4, in conjunction with option 1, offer a partial benefit under Trauma Plus for mild heart attacks and align with the universal definition. And she went on to say, Dr. Carlos has conservatively estimated that the increase in MI claims, and I'll wait for the Commissioner to tell me that myocardial infarction would be what MI stands for.
Get to an age where these things become very important. Go on.
Had conservatively estimated that the increase in MI claims under the universal definition, so option 3, would be around 25%. This no doubt would mean an increase in trauma claims of say 8 to 12%. What we'd like to understand is what room there is to move, if any, to make changes. It is expected that other players will move in some way towards the universal definition over coming months as part of their product reviews. As the traditional risk specialists will focus on the best definitions for the top 4, we should also be mindful of impacts, lapse, sales experience if no change is made, though as always, this is hard to quantify. Now, the top 4, were they the top 4 conditions in a trauma policy, including a heart attack? Is that what that is a reference to?
So, yeah, it's a reference to what are the most predominant number of claims under trauma. So cancer is the number 1. So we estimate about 60% of all trauma claims are cancer and stroke, heart attack and heart other conditions. So they're considered the top 4.
So we see from this email that Ms Nestroy's chief concern in choosing between the different options seemed to be the potential cost to CommInsure of each of those options.
Definitely an element of cost. So if you increase claims coverage, it would have an impact on premiums, yes.
And she was comparing the potential cost of increased heart attack claims if you move to the universal definition with the potential cost of increased lapse rates if you didn't move to update your definition.
Yes.
And if we turn back a page, we can see the Chief Medical Officer's response to this email at 0247, top of the page. And we see that he said, in the ideal world, I would personally move to the universal definition from 2007. Depending on the assay used, our troponin level required for current payment can be 20 times above the 99th percentile. As the 99th percentile number varies depending on what machine is used by the lab, our absolute level may discriminate against people. Also, the 99th percentile is lower in women, and so it is harder for women to reach our level, which is not ideal. I agree with Alan to pay significant infarcts post-percutaneous coronary interventions, even if it is a reduced benefit. So that was the view of CommInsure's Chief Medical Officer.
Yes, it was.
He explained that CommInsure's existing definition in 2012 could discriminate against people depending on what machine was used by the lab,
Yes.
and it could discriminate against CommInsure's female customers,
Yes.
and it required troponin levels 20 times higher than those required by the universal medical definition of a heart attack.
Yes.
And what weight were these concerns of the Chief Medical Officer at CommInsure given in the product development process that followed?
I guess it's difficult for me to ascertain that, given I wasn't there at the time.
Well, unfortunately, you are the person I have to ask,
Sure.
Ms Troup. Are you able to assist us at all in understanding what weight was given to the views of your Chief Medical Officer, who said he would personally move to the universal definition from 2007?
So I feel through the reviewing the documents, there was definitely a lot of discussion, and so it was considered, but unfortunately the business did not move forward on changing the definition.
And should the business have done that?
Yes, they should have.
All right. I tender this email, Commissioner.
Emails concerning heart attack definition, product upgrade, 11 April 2012, CBA 0001 0528 0247, Exhibit 6.155.
And in April 2012, a further product design description was prepared. Have you seen that from the documents?
Yes.
And that document again noted that current movements in the industry were leaving CommInsure behind in relation to its heart attack definition.
Yes.
And it noted that because heart attacks were one of the top four, the big four trauma events that attract advisor attention, CommInsure might start losing revenue if it was not competitive in that space. Do you recall seeing that?
Yes, I do.
And the document proposed as a way forward the fourth option that Ms Nestroy had proposed, which was to introduce a partial benefit for minor heart attacks. Is that right?
Yes, I recall reading that, yes.
And that document, the product design description document, which was a formal document in the updating of medical definitions process, is that right?
Yes, it's the document for a product upgrade, but yes, in part, medical definitions will be part of that, yes.
It made no reference to any of the concerns that had been raised by your Chief Medical Officer, did it? The discrimination concerns, his desire to move to the universal definition from as far back as 2007.
Yes, I don't recall reading that in that document, no.
And that proposal, the proposal to introduce a partial benefit for minor heart attacks, was provided to the reinsurers, RGA.
Yes.
And there was a workshop involving RGA and CommInsure in August 2012.
I'll rely on you for that date, yes.
You don't recall that?
I don't recall the date, but there were meetings.
There were meetings with the reinsurer
Definitely.
around that time. Are you
Yes.
happy to accept
Yes,
that?
thank you. Thank you.
And on the 24th of August 2012, the third universal definition of myocardial infarction was published.
Yes.
And then in September 2012, a further product design description was prepared, and it reflected the proposal, the option number 4 proposal, to introduce a partial benefit for minor heart attacks and change the name of the existing heart attack definition to heart attack of a specified severity.
Yes.
But in October 2012, your reinsurer, RGA, told CommInsure that it would not support the introduction of a partial benefit for minor heart attacks.
That's right.
And after this, the product team continued to investigate the introduction of that partial benefit. Is that right?
Yes.
But in March 2013, it was decided that the partial benefit for minor heart attacks wouldn't be included in the forthcoming August 2013 product update.
That's correct.
And the reason given was that current experience and risk appetite restricts any movement which would impact profit. Do you recall reading that?
Yes, I do.
So commercial factors led to that proposal being dropped,
Yes.
and Dr. Monday's concerns about the impact on customers fell by the wayside.
Yes.
Instead, the only change that was made was to rename the existing heart attack definition heart attack of a specified severity.
That's right.
And not long after that, the next product development cycle began for the May 2014 product disclosure statement.
That's correct.
And in October 2013, a draft product design description was prepared, and it reintroduced the proposal for a partial benefit for a heart attack of limited extent.
Yes.
But in November 2013, RGA again expressed concerns about product changes with costs attached to them.
Yes.
And later that month, the proposed partial benefit was removed from the draft product design description on the basis that it was not supported by the reinsurer.
Yes.
So again, no change was made to the heart attack definition at that time.
That's right.
But by that stage, in May 2014, a number of other insurers had updated their definitions to reflect the universal definition of heart attack.
Yes, that's right.
And as you said earlier, you accept that CommInsure's failure to update its definition at that stage was a commercial misjudgment.
Yes.
Do you accept that it was a commercial misjudgment that had consequences for CommInsure's policyholders?
Yes, I do.
Adverse consequences?
Yes, I do.
Do you accept that that misjudgment was, at least in part, the result of focusing on commercial considerations and not adequately taking into account the interests of your customers?
Yes, I do.
Or the potential risks associated with not updating the definition, such as reputational risk to CommInsure?
That's right.
And in May 2014, CommInsure's then Chief Medical Officer, Dr. Benjamin Coe, circulated a paper that again recommended that the heart attack definition be updated.
That's right.
And if we go to CBA 0001 0528 0292, and we turn to, within this document, 0298. Are you familiar with this document, Ms. Troup?
Yes, I am.
Yes. And if we turn to 0298, this is a document written by Dr. Coe, then the Chief Medical Officer at CommInsure, and we can see his recommendation at the bottom of the final page of the document. I'm sorry, yes, on the bottom of the final page. Our current definition of heart attack should be reviewed in order that it is aligned to clinical advances and practical concerns of medical assessment of claims. Otherwise, in order to stick strictly to definitional terms, there may be unnecessary time wasted, financial and opportunity costs, legal implications, and the tarnishing of brand reputation when trying to decline legitimate claims that would reasonably have been admitted within the spirit of the policy. That was Dr. Coe's recommendation,
Yes, it was.
and Dr. Coe recognised the potential legal and reputational risks to CommInsure from not moving to update its definition.
Yes, he did.
I tender that document, Commissioner.
Heart attack insurance definition, a review by Dr. Benjamin Coe, CBA 0001 0528 0292, Exhibit 6.156. Is all the date Do we have a date on it? You said, I think, May 14, but have we got any more precise date?
9 May, I think.
Yeah, I think it is 9 May.
Oh,
Commissioner?
yes, I'm sorry. We have a covering email that suggests that it's dated the 9th of May 2014.
The date 9 May 14 will become part of the exhibit.
Thank you, Commissioner.
Note.
Then in 2015, the non-executive members of CMLA's Board Risk Committee initiated the Life Claims Customer Advocacy Review Project, which is referred to, I think in your statement, as CCAR.
Yes.
And what did that project involve?
It involved, I think there was 9 or 10 themes that were concerns in the business, and it involved bringing in an expert from the industry to provide clarity on those and what potential responses were needed by the company.
So a report from that project was delivered in September 2015.
That is right.
And that is CBA 0001 0527 1967. Now, if we turn to the third page, 1969, we can see the executive summary of this report, and at the top we see an explanation of the aims of the project to understand how we are positioned in terms of customer advocacy, firstly, but also risk management in key areas of life claims management that have been identified as being potentially complex or prone to error or inconsistent treatment. We will fix any specific claims identified as impacting customers, put in place actions to mitigate further issues occurring in these specific areas, and recommend any additional actions required. And beneath that, we see the primary findings of the review. And the second item in that list is some trauma product definitions are either outdated due to medical developments or confusing for customers. For example, and one of the three was heart attack. And then the document sets out major recommendations in the executive summary. And the first recommendation was consider updating trauma product definitions for bladder cancer, severe rheumatoid arthritis and heart attack. And if we turn to 1974, we can see that the method applied by the review is depicted on this page in assessing the themes that were addressed in the review. So this was a review that we can see was focused on customer advocacy.
Yes.
And we see that low customer advocacy is when a product definition is confusing to customers, product definition doesn't align with medical advances in treatment and diagnostics, claims assessment is not consistent, medical opinions are not consistent, a high proportion of claims are declined, and non-disclosure and non-legitimate claims are not managed effectively, potentially adversely impacting all policyholders. So those were circumstances that were characterised as low customer advocacy.
Yes.
And high customer advocacy was when the policy definition was clear and met customer expectations at claim time, the claims assessment was consistent, the medical opinions were consistent, the decline rate for legitimate claims was low, and non-disclosure and non-legitimate claims are managed effectively, protecting all policyholders. Now, if we turn to page 11 in the document, which is 1977, we can see the customer advocacy analysis for the heart attack definition. And we see this page begins with a problem statement The clinical definition of heart attack has changed, and the criteria used to make the diagnosis have also changed in clinical practice, as more sensitive tests are now available. Customers may be told they have had a heart attack, but they do not meet the CI definition and are unable to claim. Our product definition, and therefore pricing, is no longer in line with the clinical definition. Now, these were the issues identified by Dr. Monday and Ms. Nestroy back in 2012, weren't they?
Yes.
But by late 2015, nothing had been done about those issues.
That's right.
And we can see on the slider depicted on this page that CommInsure recognised that in terms of customer advocacy, it had got worse between 2011 and 2015.
Yes.
Was that acceptable, Ms. Troup?
No.
I'll tender that report, Commissioner.
Life Claims Customer Advocacy Review Report of September 2015, CBA 0001 0527 1967, Exhibit 6.157.
And following this report, CommInsure began a project to review certain medical definitions, including the heart attack definition. Is that right?
Yes, it is.
And then, as we heard earlier, in March 2016, there were the media reports about the heart attack definition.
Yes.
And the amendment to the definition was accelerated to occur in March 2016 with effect back to May 2014.
Yes, it was.
Has CommInsure now taken steps to ensure that more than just commercial considerations are taken into account in its product review processes?
Yes, it has.
And could you explain those steps?
Yeah, a few examples. Firstly, in terms of our policies and practices, so we talked earlier about one of our product development guidelines. There's specific references now in terms of customer advocacy and to ensure that the documents are considering that. Secondly, and I think you might have said this before, a lot of those documents are focused on what is changing as distinct from what's not changing and the implications of that. So now we ensure that we're focusing on both sides of the product development cycle. It'd also be fair to say that the experience of the last 18 months and 2 years has really created a different culture within CommInsure to really reinforce the importance of customer advocacy.
I want to put a series of short propositions to you to conclude this topic that I've been asking you questions about, Ms. Troup. You accept, I think, that CommInsure knew from at least 2012 that its heart attack definition didn't reflect the universal definition of heart attack.
Yes, I do.
And you accept that until the name of the definition was changed to heart attack of specified severity in 2013, people reading the policy would have assumed that it was intended to apply to all heart attacks.
Yes.
And do you accept that in making decisions not to update the definition between 2011 and 2016, CMLA was motivated by commercial considerations?
Yes.
And that it did not adequately take into account the interests of its customers in making those decisions?
Yes.
Thank you. If that's a convenient time, Commissioner, I will need to continue with Ms. Troup in the morning, but that might be a convenient break.
9:45.
Yes, thank you,
We
Commissioner.
have you back in time to begin at 9:45, Ms. Troup.
Yes, Mr. Commissioner.
We'll adjourn until then. Yes, Ms. Orr.
Ms. Troup, late yesterday I asked you a series of questions about the product development phases in which consideration was given to changing the definition of heart attack over a multi-year period. You recall that?
Yes, I do.
And I put a number of propositions to you which were based on a number of documents that were provided to the Commission by CMLA. And for completeness, I want to tender those documents that I was referring to yesterday. So if I could do that first, Commissioner.
Yes.
The first document is a heart attack definition updated summary document, CBA 0001 0525 0096.
Will become Exhibit 6.158.
The second is a draft product design description from February 2012, CBA 1002 0004 0010.
Becomes Exhibit 6.159.
A draft product design description from April 2012, CBA 1002 0004 0023.
Becomes Exhibit 6.160.
A draft product design description from September 2012, CBA 1002 0004 0041.
Exhibit 6.161.
A draft product design description from March 2013, CBA 1002 0004 0351.
Exhibit 6.162.
A draft product design description from October 2013, CBA 1002 0004 0274.
Exhibit 6.163.
And finally, a draft product design description from November 2013, CBA 1002 0004 0315.
Exhibit 6.164.
Now, I want to turn to a new topic, Ms. Troup. I said to you yesterday when I took you to Mr Kell's letter to CMLA from the 22nd of March last year that I wanted to deal with 3 of the issues that Mr Kell described in that letter. I want to go to the second of those issues now. So if I can take you back to that letter, which is ASIC 0066 0001 1134. Now, we've dealt with the first of the issues, which was the use of out-of-date medical definitions. And the second issue I want to deal with is discussed on pages 15, 15 and 16 of the letter at 1148. 1148 and 1149, if we could have both of those on the screen. Now, this second issue relates to CMLA's advertising and promotion of heart attack cover. And we saw earlier that until March 2016, CommInsure's heart attack definition applied only to some heart attacks, severe heart attacks. You recall that, Ms. Troup?
Yes, I do.
And we see from this letter at paragraph 88 that as part of its investigation, ASIC considered advertisements on CBA and CommInsure's websites, as well as information that was made available to consumers through financial advisors.
Yes.
And we see from paragraph 89 that Mr Kell was concerned that those advertisements were misleading and deceptive, and that by those advertisements, CMLA was also breaching its obligation to act in the utmost good faith in Section 13 of the Insurance Contracts Act.
Yes.
And in paragraphs 90 to 91, Mr Kell gave some examples of concerning statements in the advertisements, which I'll come back to as we look at some of those advertisements. But the essence of the concern was that the statements were not sufficiently qualified or limited to ensure that readers were aware of the specific criteria that they were required to meet to satisfy the heart attack definition.
Yes, that's how I understood it, yes.
And we see from paragraph 92 that Mr Kell told CMLA that ASIC was currently considering enforcement options in relation to these potential contraventions and would contact CMLA shortly to discuss how the matter may proceed going forward.
Yes.
Now, with that background, could I ask that you look at some of these advertisements? If we could go to ASIC 0066 0001 1097. And if we could turn, that's an email attaching some of the advertisements and providing them to ASIC. If we could turn to 1098.
Suspect the attachment will be new document.
ASIC 0066 0001 10 excuse me 1098. Todd, it's coming, Commissioner. I think it's difficult for me to ask you any questions about this document until it's on the screen, Ms. Troup.
Thank you. I'm sorry, Commissioner. I think it might be best if we take just a couple of minutes to ensure that we've got the right document. In your hands as to whether you'd prefer to stand down for a few minutes.
If I sit here and stare balefully at the screen, it'll work quicker, won't it, Hazel? But there again,
We think it may be another few minutes, Commissioner.
Rather than my staring at everybody and causing havoc, if I leave and if you let me know
Yes.
when we're ready to go.
Thank you, Commissioner. I
Yes.
apologise for
No,
that.
these things happen.
Or stroke. It's part of our tailored insurance range. And in the left-hand column, under the heading Features, it says, helps cover the medical costs and lessen the severe lifestyle changes that result from any of 48 major illnesses or injuries, such as heart attack, stroke, cancer. Now, there was no indication anywhere in this advertisement that the words heart attack covered only some heart attacks, was there?
Not on that page, no.
On any page in this advertisement, Ms Troup?
Not what you're showing here, no.
Would you like to see the other pages of this advertisement?
No?
No? You accept that there was nothing in the pages that dealt with trauma cover on the website at this time that indicated that the references to heart attack were intended to cover only some types of heart attack?
No, not on these pages.
You keep saying that, Ms Troup. What pages would you like to refer to?
Oh, apologies. If you click through to learn more, it takes you to the PDS, which explains
see.
things further.
I see.
Apologies.
So there was a hyperlink to the product disclosure statement,
Yes.
and the definition was in the product disclosure statement.
Yes, it was.
But there was no indication in the advertisement that the words heart attack should be read as heart attack of specified severity,
That's correct.
and there was no reference to the particular heart attack definition on the pages of the website, was there?
That's right.
Do you accept that a person reading this advertisement would have been likely to believe that CommInsure's trauma policy covered all heart attacks?
Yes, based on that page, yes.
Well, let's go to the page that you're referring to. I think that's 1104. Perhaps if we could bring up 1103 and 1104, we'll see the full 4 pages containing this advertisement. I think what you may be referring to is something that appears in the information at the bottom of the right page. Is that right?
Yes.
This information has been prepared without considering your personal objectives, financial situation or needs. Before acting on it, please consider its appropriateness to your circumstances. Refer to the relevant product disclosure statement and financial services guide. And that was a hyperlink. Is that right?
Yes.
Now, is it reasonable for a reader, firstly, to expect that CBA has accurately summarised the key parts of the policy in the advertising material?
Yes.
And is it reasonable for a consumer to expect that CBA has not overstated the coverage available?
Yes.
It is not reasonable, I want to put to you, for CBA to expect a person to scroll much further down the page to click through to a PDS and locate the definition that will explain to them that when you refer to a heart attack, you're really referring to a heart attack of a particular severity.
I think that's fair.
So do you accept that this advertisement was therefore misleading to consumers about the coverage of your trauma policies for heart attacks?
Yes.
All right, thank you. Now, if I could tender that advertisement, Commissioner.
CBA website, December 12 to March 16, web capture, tailored life insurance, ASIC 0066 0001 1098, exhibit 6.165.
I could ask that you look at another advertisement that was provided to ASIC. This one is at ASIC 0066 0001 1106. And this is also an extract or a web capture from the CBA website. Now, this could be accessed, we know again from correspondence between CMLA and ASIC, from the CBA website from about June 2013 to March 2016. Does that accord with your recollection?
Yes, it does.
And up the top of this web page, under the word trauma, we see this cover can pay a lump sum to help with medical costs if you suffer any one of our specified trauma conditions, such as cancer, heart attack or stroke. It's part of our tailored insurance range. And then we see further down under how it works. Do you see that, Ms. Troup?
Yes, I do.
This cover can help with medical costs and also help to lessen lifestyle changes that result from any of 48 major illnesses or injuries, including heart attack, stroke, cancer or blindness. So again, there was no indication that the words heart attack only included some heart attacks.
That's correct.
No reference to heart attacks of specified severity.
That's correct.
And no reference to the particular definition in the policy.
That's correct.
And again, do you accept that a person reading this advertisement would have been likely to believe that CommInsure's trauma policy covered all heart attacks?
Yes,
Not just heart attacks of a particular severity.
that's right.
So do you accept as well that this advertisement misled customers?
Yes,
Attend to that advertisement, Commissioner.
CBA website web capture, June 13 to March 16, trauma, ASIC 0066 0001 1106, Exhibit 6.166.
Could I ask that you be shown now, Ms. Troup, ASIC 0066 0001 1112. Now, this was a two-page pamphlet. Perhaps if we could have the second page brought up on the screen at the same time. It was a pamphlet that was accessible from the CommInsure website from June 2015 to March 2016.
Sorry, what dates, Ms Orr?
June 2015 to March 2016. Does that accord with your recollection, Ms. Troup?
yes,
And under the heading, what is trauma cover, on the left-hand side, it says trauma cover pays a one-off lump sum of up to $2 million if you suffer from a specified medical condition, regardless of whether you are prevented from working or not. And then under the heading, what is covered, on the left-hand side towards the bottom of the page, what is covered, the first category in the list is heart disorders, and the first item in the list is heart attack. Now, by this time, in June 2015, the policy itself didn't say heart attack, did it?
no,
It said heart attack of specified severity.
yes,
But there's no reference to that qualification here,
no,
and no reference to the definition from the policy.
that's correct.
And there's not even a reference to the product disclosure statement, is there? Perhaps if we can pan back so that you're able to look at the entirety of the document.
No,
Should there have been, Ms. Troup?
yes,
There's no reference to the fact that the benefit would only be payable if the insured met the particular definitions in the policy. We don't even see that sort of statement in this pamphlet.
no,
And do you accept that a person reading this pamphlet would also have been likely to believe that CommInsure's trauma policy covered all heart attacks,
Yes,
not just heart attacks of particular severity.
that's correct.
Do you accept that this pamphlet was also misleading to consumers?
Yes.
Thank you. I tender that pamphlet, Commissioner.
Trauma cover pamphlet, June 15 to March 16, ASIC 0066 0001 112, Exhibit 6.167. Just before we leave that, Ms Orr, I see that a number of the items, including coronary artery angioplasty, have an asterisk. I see partial trauma cover benefit paid.
Yes.
Is where the asterisk leads.
Yes.
Yes.
Now, the fourth and final advertisement I want to take you to, Ms Troup, is at ASIC 0066 0001 114. Now, this was another pamphlet accessible from the CommInsure website from June 2015 to March 2016. Does that accord with your recollection?
Yes.
This pamphlet was called The Big Four Trauma Claims, and if we turn to the second page, 1117, if we could turn to 1117, which is page 2 of the pamphlet, under the heading What is Trauma Cover, the pamphlet said, trauma cover is an insurance product that pays a lump sum benefit for defined traumatic medical conditions or events and should form part of any risk protection portfolio. It covers a wide range of conditions, including the big four trauma claims of cancer, stroke, heart attack and coronary artery bypass grafts. And then if we turn to 1123 within the document, we see that the document addresses heart attacks specifically. The first heading on the page is What is a heart attack? On average, the human heart beats 70 times per minute to circulate blood around the body. Like other active muscles, the heart needs a steady supply of oxygen-rich blood to remain healthy and function properly. A heart attack happens when one or several of the heart's main arteries are blocked and oxygen-rich blood no longer reaches it, resulting in the death of heart cells. Such blockage is usually caused by a blood clot becoming lodged in an artery, with the clot typically arising after rupture or tearing of arterial plaque. Now, that's not how heart attack was defined in the policy, is it, Ms Troup?
No.
This page doesn't make any reference to the definition of heart attack in the policy, does it?
No.
It doesn't even warn the reader that there is a different definition.
No.
Do you accept that a person reading this document would have been likely to believe that CommInsure's trauma policy covered all heart attacks,
Yes.
not just heart attacks of particular severity?
Correct.
You accept that this document was misleading to consumers?
Yes.
I tender that document, Commissioner.
The Big Four Trauma Claims pamphlet, June 15 to March 16, ASIC 0066 0001 114, Exhibit 6.168.
Now, we saw from the earlier letter, the 22 March 2017 letter from Mr Kell, that Mr Kell advised CMLA that ASIC was considering what enforcement action it would take in respect of the misleading material in these advertisements. Did ASIC take any enforcement action against CommInsure in relation to any of these advertisements?
I'm not sure if enforcement action is the correct term, but we did come to an agreement in terms of how to close the matter.
We came to an agreement as to how to close the matter.
Yeah.
Well, I just want to deal with that in a bit of detail, Ms Troup, and see exactly what we understand happened. Can I start by taking you to some emails that are ASIC 0066 0001 1302. And if we start at 1303 and 1304 on the screen, we can see from the email that commences at the bottom of the left-hand page that on the 17th of October 2017, Tim Mullally, the Senior Executive Leader of Financial Services Enforcement at ASIC, wrote to James Myerscough, the Chief Risk Officer of Wealth Management at CBA. Have you seen these emails before, Ms Troup?
Yes, I have.
And Mr Mullally said that he had set out some wording for the CommInsure advertising matter, which would form the basis of a letter as between ASIC and CommInsure, formally resolving the matter, and also form the basis of a media release to be issued by ASIC in relation to the matter. You see that reference in the correspondence from Mr Mullally to Mr Myerscough?
Yes, I do.
And he then set out ASIC's proposed wording for the basis of a media release to be issued by ASIC. And that wording, we can see from the right-hand page, included references to ASIC's concern that CommInsure had made misleading and deceptive statements on its websites. You see that reference?
Yes, I do.
It included that underneath that, the statements may have led a policyholder to believe they would be entitled to a lump sum payment when they suffered a heart attack, when in fact they would only be paid if they suffered a heart attack which met certain medical criteria.
Yes.
And we see that the proposed form of words also included, a few paragraphs down, a statement that CommInsure acknowledged that prior to March 2016, the statements may have been misleading and deceptive. Do you see that reference, Ms Troup?
Yes, I do.
And the proposed wording also included this statement: to resolve ASIC's concerns, CommInsure has agreed to make a voluntary community benefit payment of $300,000 to blank. This payment will be made by blank. You see that?
Yes, I do.
And there is also a reference to CommInsure commissioning an independent compliance review of its advertising sign-off processes and procedures.
Yes.
And finally, a statement that ASIC has now concluded its investigation into the life insurance business of CommInsure, noting that ASIC will engage on the ongoing reviews. So that was the form of words for the media release that ASIC proposed to CMLA.
Yes.
And then underneath the proposed words, if we pan out, we'll see that Mr Mullally said to Mr Myerscough, we will of course need to agree with CommInsure the timing of a number of steps, the CBP, Community Benefit Payment recipient, and the nature and details of the review. Could you please consider and let us know whether this is sufficient for CommInsure to resolve the matter, including by way of payment of the community benefit payment in the absence of infringement notices. Now, Ms Troup, do you know how the figure of $300,000 for the community benefit payment was arrived at?
No, I can't remember.
You don't know. You don't know whether that was proposed by ASIC or by CMLA?
No, I can't. No, I'm sorry, I can't remember how that came about.
Are you aware that at this time, in 2017, the maximum penalty for a contravention of Section 12DB of the ASIC Act by a body corporate for misleading and deceptive conduct was 10,000 penalty units?
Yes, I recall that, yes.
So that's almost $2 million per contravention.
Can I trust your maths? Yes.
I want to take you back to what happened after this email was received from Mr Mullally by Mr...
Before you leave that, what's meant by let us know whether this is sufficient for CommInsure to resolve? What did you understand by that, Ms Troup?
I think it was the two organisations resolving the matter that was satisfactory for both companies.
The regulator asking the regulated whether the proposal was sufficient in the eyes of the party alleged to have broken the law. Is that right?
I guess in terms of, we could have taken an approach of continuing to defend our position, and so this was the alternative.
Yes.
There was no need for you to defend your position, was there, Ms Troup? Because you were going to be able to consult with ASIC about a mutually agreeable resolution of the matter.
Yes, so there could have been other alternatives to resolve the matter.
Was ASIC presenting any other alternatives as ways of resolving the matter?
Well, I think ASIC always reserve the right to continue the enforcement action.
Where do we see that here?
Maybe not in that correspondence, but that's my understanding. ASIC, in these correspondence, it doesn't limit their rights or abilities to do.
No, but the
that.
tone of this correspondence is not suggestive of ASIC considering in any active way any enforcement action, is it?
Not in this correspondence.
All right, well, let's look at what happened after this correspondence was received. If we pan back to the left-hand side of the page, we see that Mr Myerscough said, "Dear Tim, thank you for your letter below. We will consider it and respond as soon as possible." And then a couple of weeks later, having received no response, we see, if we go to the top of the page, that the acknowledgement of the letter by Mr Myerscough was on the 17th of October, and we'll need now to bring up 1302 next to 1303 so that you can see the date of the email at the top of the page. So a couple of weeks after getting that acknowledgement that the letter had been received, Mr Mullally followed Mr Myerscough up on the 2nd of November. He wrote to Mr Myerscough and said, "Dear James, can you please provide an update on your consideration of the below?" Do you see that?
Yes, I do.
Now, the following day, Mr Myerscough responded. We see this from the left-hand side, 1302, and he copied you on this email. Do you see your name there?
Yes, I do.
And Mr Myerscough attached a different form of wording for the media release to be issued by ASIC, which he said would formally resolve the matter between ASIC and CommInsure and form the basis of ASIC's media release.
Yes.
So CBA suggested to ASIC what ASIC should say in its media release.
It provided feedback, yes.
With a different form of words for ASIC to use in its media release.
Yes.
And were you involved in the drafting of the alternative wording?
Yes, I believe I was.
Yes. That alternative wording is at ASIC 0066 0001 1306. Now, if we could bring up Mr Mullally's form of words on one side of the screen and compare that with CBA's proposed form of words, we'll need ASIC 0066 0001 1302 at 1304 on one side of the screen and this document on the other. And before we look at the content, I see a comment in the proposed CBA alternative with the initials HT. Are they your initials? Is that your comment there, Ms Troup?
Yes, it is.
Okay. Now, if we compare the text of these two, we can see that they are largely the same. But if we look about halfway down Mr Mullally's draft, we can see, do you recall I drew your attention to the acknowledgement by CommInsure that prior to March 2016 the statements may have been misleading and deceptive?
Yes.
And if we look at the same line in CBA's draft on the left-hand side, the proposal was CommInsure acknowledges that prior to March 2016, ASIC's concerns could be reasonably held. That was the proposed alternative form of wording.
Yes.
Did ASIC accept CBA's form of wording in substitution for its proposal?
I'll confess I'm not sure, but I'm sure you have the the release that was finalised. So.
Let's go to that. I'll need to tender both of these documents, Commissioner. The email chain between Mr Myerscough and Mr Mullally, and the attachment, which was the CBA proposed alternative form of wording for the media release.
Exhibit 6.169 will be emails October-November 17 between ASIC and CBA concerning CommInsure advertising matter, ASIC 006600011302. Exhibit 6.170 will be CBA draft of ASIC media release to resolve CommInsure advertising matter, ASIC 006600011306, Exhibit 6.170.
Now, that email chain that I've just taken you to was in October and November 2017. Can I ask you now to look at a letter that ASIC sent to you on the 28th of November, which is ASIC 006600020073. This was a letter from Mr Mullally to you. I can bring up the last page to show you that, or do you recall that this is a letter from Mr Mullally?
Yes.
Yes, dated the 28th of November 2017, and we see that it dealt with the investigation into the advertising concerns and set out the background to that investigation. And over the page at 0074, we see in paragraph 9 Mr Mullally expressing views about the advertisements containing misleading representations. Do you see ASIC is concerned that?
Yes.
ASIC considers various representations in the 4 advertisements gave the impression that CMLA would make a lump sum payment to an insured if they suffered a heart attack, when in fact the insured would only be paid if they suffered a heart attack which met certain specific medical criteria. Now, if we turn to 0076 in this letter, Mr Mullally explained in paragraph 22 that ASIC's concerns extended beyond the 4 advertisements because substantially similar wording was contained within other advertisements for CMLA's Simple Life product sold directly to consumers and thereby increasing the number of consumers potentially affected. And then if we turn to 0077, we see the final or the penultimate part of the letter is headed Action to be taken by CMLA. In recognition of ASIC's concerns, CMLA will A, acknowledge that prior to March 2016, ASIC's concerns as set out in this letter in relation to the 4 advertisements could be reasonably held. That was the language we saw from your proposed alternative wording for the media release.
Yes.
B, make a voluntary community benefit payment of $300,000 to the Insurance Law Service to be paid by no later than close of business on a particular date. C, commission a compliance review of its advertising sign-off processes and procedures, which will be subject to an independent assurance review, and advise ASIC by the 15th of December 2017 the name of the proposed independent reviewer. And D, CMLA will report to ASIC by the 30th of June this year on the results of the review and the changes implemented. So that was the letter that Mr Mullally sent to you on the 28th of November 2017.
Yes.
I tender that letter, Commissioner.
Letter ASIC to CMLA, 28 November 17, ASIC 0066 002 0073, Exhibit 6.171.
So we see from that page that the first action to be taken by CMLA was an acknowledgement that prior to March 2016, ASIC's concerns could be reasonably held. Now, prior to your evidence today, has CommInsure ever acknowledged that the advertisements contain misleading representations?
Not in that language, no.
Why not, Ms Troup?
Our position at the time is, while we understood ASIC's concerns, we didn't entirely agree with them.
What makes you able to make that acknowledgement today, giving evidence in the Royal Commission that's different from the information that was available to CommInsure at the time that it was negotiating the resolution of this matter with ASIC?
Sorry, could you ask that again?
Well, I don't understand why the difference between CommInsure's position at this time and your position here in evidence in the Royal Commission today.
I think at that time we were still defending our position and believed that there was other circumstances around, but sitting here now looking at the way it was positioned, I can see how ASIC's concerns were legitimate.
And you can see, and you've given evidence that the advertisements were misleading to consumers.
Yes,
But CBA was not prepared to acknowledge that in its dealings with ASIC
that's correct.
and has not publicly acknowledged that at any time before your evidence today. Is that right?
Yes.
Now, can we go to ASIC's media release in relation to this investigation, which is ASIC MR 17447MR. I'm sorry, that's the name of the media release. It's RCD 0015 0002 2133. Now, this is the media release that ASIC published on the 18th of December last year.
Yes.
It's a two-page media release. If we could have both of the pages on the screen, we'll see that as published, it contained no acknowledgement by CommInsure that the statements in the advertisements may have been misleading or deceptive.
Yes.
It contained no acknowledgement by CommInsure even that ASIC's concerns about the advertisements were reasonably held.
That's right.
ASIC elected not to include that form of wording, it seems.
Yes.
And the media release contained no acknowledgement by CommInsure of any form of wrongdoing in connection with these advertisements.
That's right.
Should it have, Ms Troup?
Again, I think that's probably, given it's ASIC's media release, I think that's a matter for
It's a
ASIC.
poor question on my part because it couldn't have, could it? Because you hadn't made any acknowledgement.
That's correct.
Now, the media release records that CommInsure made a voluntary $300,000 community benefit payment.
Yes, I'm not sure I see the word voluntary, but yes, I see we will make the payment down the bottom.
It was a voluntary payment, is that right?
Well, it was part of the agreement with ASIC, so if it wasn't for that, we wouldn't have done it.
I see.
Yep.
It also contained a reference to CommInsure commissioning the compliance review of advertising and sign-off processes,
Yes.
and the matter then ended there with this media release issued in December last year.
The matter with ASIC?
Yes.
Yes, but we did do the review and provide that report to
Yes.
ASIC. Yes.
So you did what ASIC had asked you to do in terms of the review of your advertising sign-off processes.
Yes, we did.
But the matter ended there in terms of the resolution that you had negotiated with ASIC for the advertising.
Yes.
this was a very good outcome for CBA, wasn't it, Ms Troup?
No, I probably wouldn't characterise it that way. At that time, we felt that we did have elements of defence.
Can you tell me what they were?
From memory, the two that come to mind was around the context of the advertising in terms of they were in one element of a broader website and references to advisors. And I think the second element was, in general terms, we think consumers would understand that an insurance policy does have defined terms. They're the two I can recall at this time, Commissioner.
You don't think a consumer reading the website might think that heart attack, medical term, if the doctor tells me I've had a heart attack, I've had a heart attack? Don't think that'd be the chain of reasoning the ordinary consumer would follow?
I think that is reasonable. I guess, as I said earlier, though, our policies do have definitions, and I think a consumer may expect that as well.
But at the end of this process with ASIC, is the position this: CommInsure did not acknowledge that it had done anything wrong? Is that right?
The thought that comes to mind with that question, Commissioner, is yes, on that particular advertising matter, but the context was we had addressed the fundamental issue of the heart attack definition, and if any customer had been misled in that time, we'd corrected that action. So I think we were thinking about it in those terms.
And if CommInsure had done something wrong, had CommInsure been punished for doing something wrong?
I think we feel the 300,000 community benefit payment was a form of punishment.
A very small amount, was it not, Ms Troup?
That's probably best for other people to judge in the context of other errors of this nature.
300,000 is 3 times the claim of the particular insured person who forms the foundation of this case study. Is that right?
Yes, that's correct, Commissioner.
And as Ms Orr has said to you, the then punishment for misleading and deceptive conduct was of the order, I think you said, Ms Orr, of 2
Under
million.
2 million for a corporate entity.
And there were at least 4 types of advertisement in issue here. Is that
Yes.
right?
Yes.
Leave aside whether you count each publication as a separate contravention. If we simply take the type of alleged contravention being singular for each advertisement, the maximum punishment was of the order of 8 million on this maths. Is that right?
Yeah, yes, sir.
At the end of the day, Ms Troup, did CommInsure come out of this process thinking that it had been punished or brought to book?
Yes, we did, sir.
Go on.
I just want to clarify one matter, Commissioner, which is that Section 12DB, which I referred to before, relates to false and misleading representations. I said misleading and deceptive. That is the provision we've used to calculate penalty.
Yes.
There are multiple sorts of provisions that could have been relied on by ASIC here. I just want to take a moment to summarise the evidence so far in terms of CommInsure's dealings with ASIC over the events that we've been discussing both today and yesterday. We heard from your evidence yesterday that in March 2017, when ASIC concluded the main part of its investigation into CommInsure, ASIC gave CommInsure firstly advance notice of its findings.
Yes.
And when ASIC formally notified CommInsure of its findings on the 22nd of March, you had conversations with Mr Sadat at ASIC about what would be included in ASIC's media release about those findings.
Sorry, which letter are we referring to?
The 22nd of March letter and the media release that came out on the 23rd of March, you had discussions with Mr Sadat about including in ASIC's media release the decision that you had made the night before to backdate the medical definition to October 2012.
Yes,
And
thank
I
you.
assume at your request, ASIC included that piece of information in its media release.
Yes,
And then when FOS notified ASIC that it considered CommInsure had engaged in serious misconduct by misleading FOS, ASIC sent CommInsure a letter,
yes,
and the letter said that ASIC expected CommInsure not to do that again,
yes.
but ASIC took no other action.
Not on that matter, no.
And then when ASIC did form the view that CommInsure had engaged in a contravention of the law by misleading and deceptive conduct and made false and misleading representations in its promotional material, it took no enforcement action against CommInsure.
No, not enforcement action, no.
It instead agreed with CommInsure that CommInsure would make the community benefit payment of $300,000,
Yes,
and it gave CommInsure the opportunity to make changes to the media release announcing that decision,
yes,
with the result that until today, CommInsure has never acknowledged that it engaged in misleading and deceptive conduct in that advertising.
correct.
I'll tender the media release, Commissioner.
ASIC media release MR 443, MR of 18 December 17, RCD 0015 002 2133, Exhibit 6.172.
Now, Ms Troup, we've discussed two of the three issues that I said I wanted to raise with you from Mr Kell's letter of the 22nd of March 2017. The third and final issue that I want to ask you some questions about is ASIC's investigation of CMLA's claims handling practices. Now, they were part of the investigation by ASIC, and they were also the subject of a number of external reviews. Is that right?
Yes,
And one of those reviews was conducted by Deloitte.
that's right.
And could I take you to the report that Deloitte produced, which is CBA 0001 0044 0027? Now, I want to take you just briefly to some parts of this report, Ms Troup. If we could turn to 0031, where we see the executive summary of the report. Under the box, the report explains that the Deloitte Claims Review Program involved two work streams. The first was a review of a sample of life insurance claims that had been declined between the 1st of May 2011 and the 30th of April 2016 to identify whether customers had claims incorrectly declined, or there was a poor customer experience in how their claim was managed. This is referred to as the claims review. And the second work stream was a review of the design of the life insurance claims handling processes, both current and planned improvements, to identify any features, factors or processes that, when operated, could systemically deliver poor customer outcomes, either financially because a claim is incorrectly declined or through a poor customer experience in how a claim is managed. That was referred to as the claims handling review.
Yes.
And if we turn to 0039, we see a discussion of the claims review, the first of those work streams. And we can see from this page that Deloitte reviewed a sample of 797 declined claims. Do you see that in the table, Ms Troup?
Yes, I do.
And on 0041, we see that there were 4 possible outcomes for the review of each claim. Do you see in the bottom part of the page that the 4 outcomes were that the decision was appropriate, that it was appropriate but there had been a poor customer experience, that there had been a customer financial impact, or an incomplete process?
Yes,
Now, Deloitte identified problems in 41 of the 797 claims that it reviewed,
yes,
and it referred those to CBA for reassessment.
yes,
And if we turn to 0043, we can see the results of that reassessment as at the time of this report. We see from the table at the top of the page that there were 12 cases where the decision was correct, but there was a poor customer experience. 8 cases where the incorrect decision was made, leading to a financial impact for the customer, and a further 11 that CommInsure was still reassessing when this report was published.
Yes.
And CommInsure completed its reassessment of those 11 cases.
Yes, it did.
And of those 11, there were a further 2 where the decision was correct, but there was a poor customer experience. Is that right, Ms Troup?
It would have been in a document, which I assume you have, so yes.
Are you able to confirm that, or would you like me to take you to that document?
If you could take me to the document, that would be appreciated.
Yes, CBA 0001 0395 0687. And if we turn to 0688, you can see that this is a letter first to Mr Austin from Deloitte on the 31st of August 2017. And I'll ask you to look at the second page, 0688. And we can see that from the table on that page, there were 2 cases where the decision was correct, but there was a poor customer experience, and 8 cases where the incorrect decision was made, leading to a financial impact for the customer.
Yes.
For a total of 14 cases, being 12 from the report plus 2 from this document, where the decision was correct, but there was a poor customer experience.
Yes.
And 16, 8 from the Deloitte report and 8 from this document, where the incorrect decision was made, leading to a financial impact for the customer.
Yes.
Now, did CommInsure remediate those customers?
Yes.
And Deloitte made a series of recommendations about how CommInsure could improve its claims handling process, is that right?
That is right.
There were 29 recommendations.
That sounds right, yes.
Now, I want to just take you to a couple of those recommendations, but I'm moving between 2 documents, and it's perhaps best if I tender both of those, Commissioner.
Deloitte report to CMLA 8 February 17 concerning claims review program CBA 0001 0044 0027 is Exhibit 6.173. Letter Deloitte to Chairman CMLA 31 August 17 CBA 0001 0395 0687 Exhibit 6.174.
Are you familiar with the 29 recommendations made by Deloitte, Ms
Yes.
Troup?
Yes, I am.
Let me ask you some questions about them, and if necessary, I'll take you to the document, but
Okay.
you may be able to answer these questions. Do you accept that they included recommendations about improving staff training,
Yes.
about improving how case managers document their conclusions on the assessment of differing medical evidence,
Yes.
about improving the documents used to communicate with customers in the claims handling process,
Yes.
about the need to improve how CMLA claims handling quality assurance reviews worked,
Yes.
and about improving the processes around the making of ex gratia payments, so that where an ex gratia payment is made, consideration is also given to what went wrong and what learnings need to be passed back to the business.
Yes.
They were some of the 29 recommendations made by Deloitte.
Yes.
And has CommInsure implemented each of those 29 recommendations?
Yes, we have.
And what are the key changes that CommInsure's made to its claims handling processes as a result?
There were many. I think an overarching one that picked up quite a few of the recommendations is our claims processing system, in terms of the checklist a claims manager must do before they complete a claim. And so it's their system checks and balances there. For example, they can't proceed to the next step unless they've done the step that was necessary. So that picked up a range of the recommendations, because you want to embed those processing. One of the ones that you called out then, obviously claims training. Part of our implementation, we use a package system, so every time a change is implemented, we have a training program that's done with testing to ensure that people are learning from the improvement in processes or topics. So they'd be two fairly broad areas.
All right. Now, Ms Troup, I want to turn to a different topic, having dealt with the three issues that I wanted to deal with from Mr Kell's letter to CommInsure in March 2017. I want to take you to the other specific consumer case that you've dealt with in your witness statements.
Yes.
And this case concerned another CommInsure customer whose name is also the subject of a non-publication direction, who developed breast cancer. You know which case I'm speaking of?
Yes, I do.
Now, I'm just going to refer to her as the insured. Now, the insured took out a total care plan with a company called Legal and General in 1996. Is that right?
Yes, that's right.
And what's the relationship between CommInsure and Legal and General?
So it's another part of our corporate history where Colonial had bought Legal and General.
So it was ultimately acquired into the CommInsure business?
Yes.
Now, the policy that this insured person had was similar to the one held by the other insured who I've already asked you questions about, is that right?
That is correct, yes, very similar.
And again, you've exhibited a copy of the customer information booklet for the policy to your statement, and I just want to go to that. It's CBA 051702103114, and it's the second exhibit to your statement, Ms Troup. Now, if we turn to the third page of the information booklet at 3115, we can see a description of the key features of this policy. Total Care Plan provides guaranteed renewable life, trauma and disability insurance through to the expiry date of the selected benefits, regardless of any change in your state of health, occupation or pastimes. Cover is available 24 hours per day, 7 days per week, anywhere in the world. And then under the heading Recuperator, we see the Recuperator benefit guarantees to pay a lump sum upon diagnosis of any one of the following conditions. And we see the third of those conditions is cancer.
Yes.
And again, we have an asterisk which points us to a qualifier that it doesn't cover cancer that occurs within 3 months of the policy commencing.
Correct.
Now, the insured took Recuperator or trauma cover as part of her policy. Is that right?
Yes, she did, sorry, yes.
And as we saw in relation to heart attacks, each of the conditions on this list were defined in the policy.
Yes.
And if we turn to 2011 to 2012, I'm sorry. We'll come to that. Can I just ask you a few other questions first? The policy definitions, as we saw in the first insured person's case, were updated from time to time. Is that right?
That's right.
And if a definition was updated, again, the insured would be entitled to rely on the definition that applied when she purchased the policy or any updated definition. Is that right?
That's correct.
And as you did with your other statement, you provided an annexure setting out the different definitions of cancer that applied under the policy at different times. And that was what I wanted to take you to. It's CBA 9000113 2000 at 2012 and 2011.
Thank you.
So that's the annexure to your statement dealing with this insured person, setting out the different definitions of cancer that applied over time. And we see that the first definition in that list is the definition of cancer that applied when the insured purchased her policy in February 1996. Is that right?
Yes, that's right.
And we see that the definition was updated in April 1996 and again in November 1998.
Yes.
And then it was not updated again until May 2017,
That's right.
almost 20 years later.
Yes.
And the definition that applied at the time the insured made her claim was the November 1998 definition,
Yes.
the definition that was in force over that 20-year period.
Yes.
Now, if we look at that definition, we see that it defined cancer as meaning any malignant tumours characterised by the uncontrolled growth and spread of the malignant cells that requires treatment by surgery, radiotherapy, chemotherapy, biological response modifiers, or any other major interventionist treatment, and includes cancers that are completely untreatable. And then the definition has a list of specific inclusions, and under that, a list of specific exclusions. And one of those, we'll need to bring up the second page to see this exclusion, 20, there we go. One of the exclusions was carcinoma in situ, unless leading to radical breast surgery. Do you
Yes.
see that, Ms. Troup?
Yes, I do.
Okay, so that was the definition in place at the time that this insured person took out her policy, the time that this insured person made the claim under her policy.
Yes.
That claim was made in August 2016,
Yes.
and by that time she'd held the policy for more than 20 years.
Yes.
And the definition of cancer in the policy at that time was almost 18 years old.
Yes.
Now, you've exhibited a copy of the insured's claim form to your statement. It's the 5th exhibit, CBA 0001 0513 0934. And on the second page of the claim form, at 0935, we can see that under details of trauma conditions, the insured person ticked cancer and explained that the first onset of symptoms was on the 7th of March 2016 and she was hospitalised on the 11th of March 2016. You see that, Ms. Troup?
Yes, I do.
And over the page, in answer to the question, what symptoms preceded the diagnosis, the insured person has given this information. A regular mammogram through breast screen SA identified an abnormality. I had no symptoms prior to diagnosis. And then on the 4th page at 0937, we can see that the insured had surgery a few days after the first onset of symptoms on the 11th of March 2016 and again a few days later on the 17th of March 2016.
Yes.
Now, when the insured provided this claim form, she also provided information from her GP, her surgeon and her radiation oncologist.
Yes.
Now, could I ask that you look at the 7th exhibit to your statement, CBA 0001 0513 0942. And this is the medical certificate provided by the insured's GP.
Yes.
And if we look at question 3, we can see that question 3 or question 4, I'm sorry. I'm looking for the part where, here we are. From question 3, we can see that the GP explained that this was a carcinoma in situ. Do you see that?
Yes, I do.
And that then required him to move to question 4 and answer whether or not there was surgical removal of the carcinoma in situ, and whether it involved removal of the entire organ. The question was, did surgical removal of the carcinoma in situ involve removal of the entire organ? And the answer was no. And the second question was the surgery performed specifically to arrest the spread of malignancy? And the answer was yes. So that was the information provided by the GP. The GP also attached some medical reports to this certificate.
Yes.
And if we go to 0950 within this document, this is one of the reports that the GP provided, and we can see from this report what the 2 surgeries that the insured had involved. One of the surgeries involved the removal of a portion of breast tissue measuring 33 by 27 by 12 millimetres. Do you see that?
Yes, I do.
And the other surgery involved the removal of a portion of breast tissue measuring 50 by 30 by 8 millimetres.
Yes.
And the same information was provided by the surgeon, who also provided a medical certificate,
Yes.
and by the radiation oncologist, who also provided a medical certificate.
Yes.
The case manager assigned to this claim referred it to an internal medical consultant, is that right?
Yes.
And the medical consultant's view was that the policy definition of cancer was not met.
That's right.
And that was because this was a carcinoma in situ and the treatment had not involved radical breast surgery. Is that right?
Yes.
And on that basis, on the 31st of August 2016, CommInsure denied the insured's claim.
That's correct.
And on the 7th of September, a week later, CommInsure wrote to the insured to notify her of this decision.
Yes.
And you've annexed that letter as Exhibit 18 to your statement, CBA 1004 0096 1126. This is the letter that was sent to the insured,
Yes.
and it set out the relevant part of the definition of cancer. Do you see that there, above our decision?
Yes, I do.
And then under the heading Our Decision, on the basis of the information obtained during the assessment of your claim, it is CommInsure's opinion that the above definition of cancer have not been met. The medical certificate for trauma benefits completed by your GP confirms your condition is carcinoma in situ of the breast. The medical certificate completed by your specialist confirms your diagnosis is carcinoma in situ left breast. In another doctor's letter dated the 4th of March 2016, he has noted the core biopsy confirms the presence of ductal carcinoma in situ in the left breast. A wide local excision on the 11th of March 2016 confirms ductal carcinoma in situ and no invasive carcinoma is noted. As such, the policy definition for cancer has not been met, as carcinoma in situ is excluded unless leading to radical breast surgery. Therefore, it is with regret and without prejudice to any other defences we may have that we have declined your claim for trauma benefits. That was the communication with the insured, Ms. Troup.
Yes, it was.
The letter didn't explain why the treatment that the insured had was not radical breast surgery, did it?
No.
It didn't say anything about what CommInsure considered radical breast surgery to be.
No, it did not.
Was the term radical breast surgery defined anywhere in the policy that the insured took out?
No, it was not.
Do you think that this letter provided an adequate explanation for the insured of the reason why her claim had been declined?
At the time, we thought it did, but I agree, we didn't explain what we meant by radical breast surgery at this point.
Well, how was the insured to understand what did and didn't constitute radical breast surgery when it wasn't even defined in her policy?
I think we believed that the general understanding of what radical breast surgery meant, both by us and by the medical fraternity, was a mastectomy. But you're right, we did not define that, and that did result in confusion for the customer, which we've apologised for.
So nowhere in her policy did you explain that the exclusion in relation to carcinoma in situ meant that you would not be covered for a carcinoma in situ unless you had a mastectomy.
That's right, we used the term radical breast surgery of the understanding that it meant mastectomy.
Mm-hmm. Well, the insured's medical practitioners took a different view to CommInsure about this, didn't they?
Yes, they did.
All right, I want to take you to that. Later in the month, when CommInsure sent this letter to the insured in September 2016, the insured's husband spoke to the case manager and said that he and the insured weren't happy with CommInsure's decision. You tell us that in your statement?
That's true.
And he asked CommInsure not to close the claim because he said that he and his wife were doing some further research.
Yes.
And after this, the insured and her husband sought more information from the GP and from the surgeon.
That's right.
And in February 2017, they wrote to CommInsure and provided that further information from the GP and the surgeon.
Yes.
And if we go to Exhibit 19 to your statement, CBA 0001 05 05 2573, this is the letter that the insured and her husband sent to CommInsure. And if we look at the second paragraph, we see that they explained that the purpose of the letter was to both outline the reasons they disputed the company's decision and to provide more information. We do not dispute the fact that the cancer my wife is suffering from is classified as a carcinoma in situ. What we do dispute is the fact that CommInsure does not recognise the surgery and follow-up as being radical. The policy covers situations where radical breast surgery is required. At no point does it define radical. In fact, it seems to us that your company has arbitrarily made a decision of what is radical, perhaps a mastectomy, and has applied that definition to my wife's case. So at this point, the insured and her husband were still trying to understand what your definition of radical breast surgery meant and were speculating that it might mean a mastectomy.
Yes.
Now, the insured and her husband attached various medical information to this letter, is that right?
Yes, they did.
And if we go to 2574 in this document, we see the information that was provided by the surgeon. Is that right?
Yes.
And the surgeon said in their letter, this is the surgeon's statement is in handwriting at the bottom of the page. The treatment received is radical because radiology was required as an alternative to mastectomy. Radiotherapy. That was the information provided by the surgeon.
That's correct.
And that was provided in response to a letter from the insured, which explained that the insurance company wished to clarify the nature of her operation, in particular whether the surgery was radical. The definition of radical in the policy is unclear, and the insurance company seemingly arbitrarily have defined radical as requiring a mastectomy. It is my understanding, we don't have this on the screen at the moment. It is my understanding that in performing the surgery, the ample nature of my breasts meant that I did not require a mastectomy. I believe that you mentioned that had this not been the case and my breasts had been small, I would have required a mastectomy. I would appreciate it if you could confirm this by indicating below if this is the case. And we see that the surgeon has circled I confirm the above statement and written the additional portion that I read to you before.
Yes.
And if we turn to 2575, we see the information provided by the GP. The GP said, the insured has been a patient of mine for about 30 years and I can confirm that she had had radical breast surgery / treatment in 2016 for breast cancer. So 2 medical practitioners who were familiar with the insured's case told CommInsure that she had had radical breast surgery.
Yes.
And the day after this information was sent to CMLA, the claim was assigned to a new case manager within CMLA.
Yes.
And do you know why that occurred?
No.
And the new case manager referred the case to the medical consultant who'd previously considered the claim. And the medical consultant again said that radical breast surgery had not been performed, having considered this additional material. Is that right?
That is right.
And the medical consultant recommended that the case be referred to the Operational Claims Committee. What is the Operational Claims Committee, Ms Troup?
It's a forum where claims can be discussed with various members of the claims team.
And when was that committee established?
I think it was in 2016.
Was it established in response to the recommendations arising from the ASIC investigation?
No, I think it was established before then.
Okay. And what led to its establishment?
One of the things that we recognise that lots of claims can be quite complex, and we wanted to set up forums to ensure as much as possible that we make the right decisions. And so sometimes a claims information is unique, or and there's other experts in the team, and we wanted to have a committee where the claims assessors could discuss that and get further input into making their decisions.
So this particular claim was referred to that committee, and the committee considered her case and endorsed the recommendation to maintain the decision to decline the claim.
That's right.
And then on the 15th of March 2017, CommInsure again wrote to the insured and told her that it was maintaining its decision to deny the claim.
Yes.
Now that letter is Exhibit 22 to your statement, CBA 0001 0505 2578. And we see from the second page of this letter that the case manager said to the insured about halfway down the page, "We appreciate that radical surgery is not defined in the relevant product disclosure statement. However, radical surgery pertaining to the breast means radical mastectomy, which is defined as removal of the entire affected breast." That was what the insured was told?
Yes.
So the insured at this stage had provided letters from 2 doctors saying that in their view she'd had radical breast surgery,
Yes.
but CommInsure had decided, contrary to the view of those doctors, that you could only have radical breast surgery if you'd had removal of your entire affected breast.
Yes.
And the claim was denied on that basis.
Yes, it was.
Now, CommInsure was, of course, relying on a definition of cancer at this stage that was more than 15 years old. I think we established before it was about 18 years old by this point.
Yes, that's right.
And it was imposing limitations on that definition that weren't expressed in any of its policy documents.
That's right.
And it did that in a way that didn't account for the way in which the insured had been treated by her doctors or the medical opinions expressed by those doctors.
Yes.
Do you think that that was acceptable, Ms Troup?
No.
What do you think? What observations would you like to make about how these events played out?
I think there were 2 errors that occurred where our processes and procedures should have addressed, and on this particular case they didn't. The first was the emphasis of the medical opinion and the difference in medical opinions should have been considered, should have been reviewed, and there should have been a further understanding of why those doctors were saying one thing and our doctors were saying something else, and that wasn't addressed. The second one that should have happened is after the OCC, given the circumstances of this claim and how I've understood it, it should have been escalated to the next level of claims review, which would have incorporated a broader cross-section of CommInsure. And I think if those two things had happened, it would have resulted in a different outcome.
Do you think if those two things had happened, the claim would have been approved?
Yes, I do.
Do you think that the way CommInsure handled the claim fell short of the standards that the community would expect?
Yes, I do.
And do you accept that by denying the insured's claim on the basis of a requirement that was not contained in the policy and contrary to the opinion of her two medical practitioners, CommInsure breached its duty to act towards the insured with the utmost good faith?
I think ultimately that is true, but I do feel that the opinion of what radical breast surgery was initially was reasonable and genuine. But the outcome, as we've discussed, the two other errors in that process did result in us not fulfilling utmost good faith.
So do you accept the proposition that I put to you that this involved a breach of the duty to act towards the insured with the utmost good faith?
Yes, I do.
Now, in April 2017, the insured made a complaint to FOS, didn't she?
Yes, she did.
And she attached a number of documents to her complaint, and one of those was a further letter from her GP.
Yes.
And you've exhibited that as Exhibit 34 to your statement, CBA 100400971611. And we see from the first page of this letter that the GP said towards the bottom of the page, I would like to take this opportunity to support one of the other medical practitioners in saying that I believe that repeated surgery, lumpectomies, plus radiotherapy in combination constitutes radical surgery. He went on to say, and if we could have both of the pages on the screen, that would assist. I also believe that if the insured's condition had occurred about 20 years ago when the policy was taken out, that the resultant treatment of 2 excisions would, in all probability, have resulted in a left breast mastectomy. It is now current practice that the insured's condition, carcinoma in situ of the left breast, would be treated with breast-conserving surgery and radiotherapy. So medical practice had moved on, hadn't it, Ms. Troup?
Yes.
But CommInsure's definition had not.
That's true, but there is some further context which I could expand on.
Yes, please.
Yes. The definition, the carcinoma in situ anti-exclusion, when it was first introduced in 1998, we used that term radical breast surgery, but it was only in operation for 3 years, and I think reflected the language of that time. Since then, our policy and the majority of the industry has used expression carcinoma in situ, and it would only be paid if removal of the entire breast, and I think that reflects the FSC minimum standard as well. So yes, treatment had changed, but the intent of the policy and the coverage of the policy had not changed throughout that period.
I just want to make sure I understand that. So the definition between 1998 and 2017 excluded carcinoma in situ unless leading to radical breast surgery, and CommInsure took the position that that meant carcinoma in situ unless leading to a mastectomy.
Yes, we did.
But medical practice had moved on, and carcinoma in situ was, wherever possible, not treated with a mastectomy. It was treated with breast-conserving surgery.
Yes, and I guess I'm drawing the distinction between treatment versus the coverage of the policy.
But your policy was not covering the way in which carcinoma in situ had come to be dealt with because of medical advances.
Yes, but the intent of the policy was the exclusion was carcinoma in situ unless it resulted in entire removal of
see.
the breast.
I see.
That's the distinction.
I understand.
Thank you.
Now, in May 2017, the definition was updated.
Yes, it was.
And if we go back to your annexure to your statement at CBA 9000113 to 000 at 2011 to 2012, we see the definition that applied from the 5th of May 2017. The definition of cancer from that time included a number of conditions, including carcinoma in situ of the breast, which has resulted in the removal of the entire breast, or breast conserving surgery and radiotherapy, or breast conserving surgery and chemotherapy. Now, under the new definition, the insured would clearly have been covered.
That is correct.
But when CommInsure amended the definition in May 2017, it did not backdate it.
That's correct.
So it was still the 1998 definition that applied to the insured.
Yes.
Why did CommInsure not backdate that definition?
So this definition was increasing coverage, and so the approach is that applies for new claimable events.
But you had backdated the heart attack definition when you made a change to that one.
Yes, that was different circumstances. That's because that definition was out of date.
And you didn't accept that this definition was out of date, the definition that had been in place since 1998?
No.
I see. Now, a week after that definition was amended, on the 12th of May 2017, Group Customer Relations, who were again handling the FOS dispute with the insured, asked the medical consultant who'd already provided 2 opinions by that time to consider further the letter from the GP that had been provided by the insured to FOS. Is that right?
That is right.
And the medical consultant, having reviewed that letter, said, and you deal with this in paragraph 60 of your statement, while the GP has written a letter in response to the decline letter, no additional clinical information is provided. Based on all the reports provided of the cancer histopathology, plus the treatments offered, I still do not see any evidence of radical breast surgery as per the policy intent. That was the position taken by the medical consultant,
Yes, it was.
referable to the policy intent,
Yes,
but not to the policy wording.
that's correct.
And CommInsure then discussed the matter internally. We see that from paragraph 63 to 65 of your statement. And by the 8th of June 2017, CommInsure still hadn't provided a response to FOS's original request for information, which had been sent more than a month earlier on the 28th of April, and asked for a response by the 18th of May.
That's correct.
And CommInsure hadn't received an extension from FOS.
No.
It just chose not to respond to FOS's request for information.
Yes.
Was that acceptable, Ms. Troup?
No.
Do you accept that by not responding to FOS within their required time or even requesting an extension, CommInsure's conduct in engaging with the external dispute resolution entity fell below what the community would expect of it?
Yes.
And on the 8th of June, FOS sent another letter giving CMLA 7 days to provide the information, after which a telephone conciliation would be held.
Yes.
And on the 14th of June, CMLA gave a brief response maintaining that the claim should not be paid because the insured had not had radical breast surgery.
Sorry, what date was that?
The 14th of June. That's the date of the
Right.
letter that is Exhibit 44 to your statement.
Thank you.
And then in July 2017, representatives of CommInsure attended a telephone conciliation conference with the insured.
Yes, we did.
And the CommInsure representatives went to that conciliation conference with authority to settle the dispute for up to $84,650, which was half of the insured sum of $169,305.
That's correct.
Why were they authorised to attempt to settle for this amount?
It was in recognition that we hadn't defined radical breast surgery in the documents.
CommInsure knew, didn't it, that it was problematic to decline a claim based on an interpretation of the term radical breast surgery that didn't appear anywhere in the policy documents.
Yes.
The dispute didn't resolve at the conciliation conference
No, it didn't.
or in the further discussions between the parties that occurred in the following weeks.
That's correct.
It went to a recommendation by FOS,
That's right.
and the recommendation was made in August last year,
Yes.
and it was in favour of the insured.
Yes, it was.
And if we go to that recommendation, which is your Exhibit 54, CBA 0001 0517 0204, we see on the first page that the case manager set out the basis for the recommendation, and it said under the heading, was the financial services provider entitled to deny the claim? The financial services provider was not entitled to deny the claim because the policy does not define the phrase radical breast surgery, and therefore the financial services provider was not entitled to limit the interpretation to a mastectomy. The applicants have provided medical documents supporting that the insured had suffered a carcinoma in situ, which led to her having radical breast surgery. Now, that was the recommendation. That recommendation was accepted by CommInsure,
Yes, it was.
and in September 2017, that was the time when the recommendation was accepted, in September 2017. After that, I'm not sure how much after that, CommInsure paid the insured's claim. Is that right?
Yes, we did.
It paid the sum of $169,305 plus interest of just under $5,000.
Yes.
And do you agree that FOS made the right decision?
Yes, I do.
And you accept in your statement that the handling of this claim caused the insured distress?
Unfortunately, yes.
Now, the dispute was resolved at this time in September 2017, the FOS dispute, but in March this year, FOS wrote to CommInsure again about the dispute.
Yes, they did.
The case manager at FOS, who was responsible for the investigation of systemic issues, notified CommInsure that he was investigating whether this particular dispute raised a systemic issue in relation to CommInsure's interpretation of radical breast surgery as being limited to a mastectomy.
Yes.
And on the 9th of May this year, CBA responded to that point. Can I take you to your letter to FOS, which is FOS 0046 0001 2297. Have you seen this letter before, Ms. Troup?
Yes, I have.
And if we turn to the second page at 2298, we can see that FOS had asked CBA about other cases in which CommInsure had declined trauma claims for breast cancer in the previous 2 years.
That's right.
And CBA provided a table setting out those cases.
Yes.
And there were 2 cases, including the case that we're discussing, where the claim had been denied on the basis that the policy explicitly required radical breast surgery.
Yes.
And in the other case, CommInsure initially denied the claim but later decided to accept it.
Yes, the processes worked for that claim, unfortunately, and it didn't for the insured.
I see. And FOS asked for more information in response to this letter, didn't it?
Yes, they did.
I'll tender that letter, Commissioner.
Letter CBA to FOS 9 May 18, FOS 0046 0001 2297, Exhibit 6.175.
And CBA provided that further information to FOS.
Yes, we did.
And then on the 23rd of July this year, FOS wrote to CommInsure again and said that it found that there was a definite systemic issue in relation to CommInsure's interpretation of radical breast surgery as being limited to a mastectomy.
Yes.
And you've said in your statement that CommInsure is still engaging with FOS about that finding.
Yes.
Do you disagree that it's a systemic issue?
Yes, I feel like it was just an isolated event, yes.
In what way do you feel this was an isolated event, Ms Troup?
Well, based on reviewing claims in the last 2.5 years, we haven't found another circumstances where we had inappropriately declined a claim.
Does CommInsure plan to review its past claims that have been declined on the basis of its interpretation of radical breast surgery?
I must say that's something that's on my mind, having prepared for today, and something that I will discuss with the business on my return.
So there's been no decision made to do that?
Not at this stage.
Should there be a decision made to do that, Ms Troup?
As I said, I think I'd like to discuss that with the business, and our review so far has indicated in the last 2.5 years there's been no other one. But yes, it is something on reflection I'd like to think about further.
But you're not prepared to make a commitment that that will happen?
Not today, no.
Mm-hmm. What changes has CommInsure made to ensure that issues like this don't arise in the future?
Specifically, 2 things. As you indicated, we have updated our cancer definition, and radical breast surgery was only in our policy for 3 years. So it is a very small chance that it will happen again. In addition, we have reinforced our guidelines of escalation of claims of this nature, and we have also provided training on how, if it is a claim for radical breast surgery, although the new definitions apply, we need to consider the circumstances, the actual surgery, the size of the surgery and other elements, not rely on our previous intent.
In your statement, you say that the claims assessment guidance provided to case managers will be updated to state that radical breast surgery should be interpreted by reference to the level of tissue removed, among other considerations. Do you recall that?
Yes, I do.
You said that that would happen. Has that now happened?
Yes, it has.
And when did that happen?
I think it was about 2 weeks ago. I'd have to confirm.
After you provided your statement?
Yes, yes.
And finally, in paragraph 91 of your statement dealing with this insured, you made an apology about the handling of this claim. Could you just explain what it is that you or CommInsure are apologising for in connection with this claim?
Firstly, the process that she had to go through while she was dealing with her health issue didn't meet the standards that we expect. I imagine it caused her additional stress, and I apologise for that. Her claim should have been paid earlier, and again, I apologise for that as well.
I have no further questions for Ms Troup.
Thank you, Mr Karkar.
No questions, Your Honour.
Thank you very much. Ms Troup, you may step down, and you're excused, I think.
Commissioner, before we take a break and move to the next case study, we'd like to say something more about the witness statements that we've received from the 10 life insurers. We've already told you, Commissioner, about what those statements told us about the sale of life insurance products and the handling of life insurance claims, but we also asked those life insurers to tell us about how they design life insurance products, and we asked them in particular about their processes for updating medical definitions, an issue that has been raised in this last case study. As you've heard, Commissioner, medical definitions are an important aspect of life insurance policies that provide trauma cover. Whether a claim's accepted or declined depends in large part on whether the insured person meets one of the specific definitions set out in the policy. In offering insurance, an insurer can use broad or narrow medical definitions to expand or reduce the coverage that it provides. And as we've heard, the breadth of the definition will affect the cost of the policy to the insurer and the reinsurer. ASIC has taken the view that on its own, reliance on an outdated medical definition is not a breach of the law, provided that the applicable definition is clearly disclosed to the insured. However, ASIC considers, and we agree, that reliance on outdated definitions is clearly out of step with community expectations. The community expects that medical definitions in life insurance policies will appropriately reflect the community's understanding of what constitutes a particular medical definition. As we've heard
Well,
in
the
relation...
community standards or the medical professions understandings?
Both, we would say, Commissioner.
The community
committee's-
may have an understanding of, I've got a dose of the flu, when in fact they haven't.
Community standards are informed by medical
Yes.
practice is how we would put it, Commissioner.
Yes.
As we've heard in relation to CommInsure, the evidence suggests that those expectations have not always been met. And this issue is not unique to CommInsure. We asked the 10 life insurers whether they'd identified any deficiencies in their processes for updating medical definitions in life insurance policies, and 8 of the 10 accepted that there had been deficiencies in their processes for reviewing and updating medical definitions. A central theme was the lack of procedures to ensure regular and formal reviews. TAL told the Commission that it did not have formal processes in place to annually review the currency of medical definitions until 2016. TAL also did not have a formal register recording the dates and revisions made to medical definitions. AIA said that it did not have a formal definition review policy or any documented processes to review definitions for currency and relevance until last year. MLC told the Commission that it did not have a separate definition review policy or documentation of the process for reviewing definitions for currency and relevance until last year. MLC also did not have a register to track definition reviews, any requirements to review definitions on a regular basis, any regular formal review of medical literature, or a system for monitoring triggers for a potential medical definition change. Zurich said it did not have a formal process in place to review medical definitions for off-sale products until at least 2016, and recognised that it had delayed in updating the definition of severe rheumatoid arthritis in one of its products to reflect contemporary medical treatment and diagnosis. Zurich also identified internal issues concerning which person within Zurich had the power to approve changes to product features. MetLife told the Commission that until at least 2016, it did not have formal reviews of existing products at regular intervals or regular reviews of medical definitions. MetLife said that it reviewed and upgraded medical definitions in 21 products in 2016, including its definition of heart attack. AMP told the Commission that it did not have a formal and regular review of medical definitions until last year. Similarly, OnePath said it did not have a formal requirement for reviewing medical definitions prior to June last year. Finally, Suncorp told the Commission that it did not have a structured framework to proactively review medical definitions to identify the need for updates. Instead, it relied on informal processes and ad hoc medical definition updates. Suncorp told the Commission that it now intends to conduct medical definition reviews every 3 years. 2 of the life insurers did not acknowledge any deficiencies in their processes and procedures for updating medical definitions in their statements. First, Westpac did not identify any particular deficiencies in its processes and procedures from the period from 1 January 2013. And second, CMLA maintained that there had not been any findings that its processes and procedures for updating medical definitions in life insurance policies were deficient. CMLA's only acknowledgement was that its failure to update its heart attack definition was a commercial misjudgment. Commissioner, we heard in the last case study that the updating of medical definitions in CommInsure's trauma policies received significant media attention in March 2016. In October that year, the Financial Services Council introduced the Life Insurance Code of Practice, which became binding on those who subscribed to it from the 1st of July last year. Each of the 10 insurers who provided us with witness statements is a subscriber to the code. Could we please show RCD 0021 0023 0001? Now, this is the Life Insurance Code of Practice, and if we turn to 0008, we see that clause 3.2 requires subscribers to review the medical definitions in their on-sale policies at least every 3 years and to update those definitions where necessary to ensure the definitions remain current. It also requires that this review be undertaken in consultation with relevant medical specialists and that insured persons will be informed of any updates. We asked the 10 life insurers to tell us about their processes for complying with clause 3.2 of the code. Different insurers have different processes for complying with this requirement. TAL, MLC, Suncorp, Westpac, OnePath and AMP told the Commission that they now review the medical definitions in their on-sale policies on an annual basis. MetLife said that it aims to conduct its reviews every 18 months. AIA said that it seeks to review its on-sale definitions at least every 3 years, but in practice these occur more frequently. And CMLA and Zurich indicated that they only aim to comply with the 3-year requirement imposed by the code. Taking each of those entities in turn, TAL said that it has a health service team that reviews its medical definitions annually for currency. This team receives advice from a specialist advisory board comprised of medical specialists. In addition to these review processes, a further review can be conducted if considered necessary. MLC has created a dedicated medical definitions review panel. The panel is tasked with undertaking an annual review of medical definitions and recommending changes to those definitions. However, the panel does not itself have the authority to approve or make changes to products. Suncorp entrusts its Executive Manager of Product Management for life products to complete an annual review of its on-sale products. Compliance with this requirement is monitored by Suncorp's Code Compliance Committee and Compliance Team. Suncorp also employs a non-practising medical professional who is scheduled from October this year to conduct 6 monthly reviews of medical advances. Westpac conducts an annual medical definitions review, which is carried out by a working group led by a product manager within the advised products team. It provides its recommendations for changes to the pricing team, the reinsurer, senior management, and the actuarial team before these changes can be implemented. Final sign-off is then given by the Insurance Assets and Liabilities Committee. AMP established a propositions team, which is responsible for its annual medical definitions review. The assigned product owner within that team engages with AMP Life's Chief Medical Officer to review the currency of each medical definition and confirm whether it is aligned with developments in Australian medical practice. The Chief Medical Officer may refer to other medical specialists as required. The product owner also engages the claims policy team to capture feedback and complaints on the applicability and currency of medical definitions, and also considers public debate and other external developments. OnePath has added additional code compliance measures to its product management guidelines, including a requirement that medical definitions are reviewed on an annual basis, undertaken by the product team and in consultation with the Chief Medical Officer. MetLife has created a product policy to comply with the code. The product policy establishes the standards by which MetLife's insurance products are developed and managed, and applies to all products across all divisions and business lines within Australia. MetLife also relies on the input of its chief medical officers. AIA undertakes its reviews in part through the quarterly meeting of its Product Definitions Review Committee, established last year as a forum for representatives of departments to consider appropriate updates to medical definitions. It receives recommendations from consulting medical officers, the claims team, the disputes team, and the product and actuarial teams, as well as feedback from policy holders. Zurich has a risk product working group which meets on a quarterly basis to consider product issues, including updating medical definitions. This group is subject to oversight from the executive level risk proposition review group, although it is the board that has the ultimate decision-making power if any change is likely to have a material effect on revenue or profitability. CMLA has a product management policy that requires all CMLA products to be reviewed annually and medical definitions to be scheduled for review every 3 years at a minimum. The CMLA teams responsible for product management undertake these reviews. When a review of medical definitions is initiated, a working group is established. That group works with representatives from CMLA's internal medical team, claims team, product, pricing and underwriting. After the working group agrees revised definitions, a CMLA steering committee endorses the preferred wording and minimum standards. Across the various entities, triggers for medical definition changes outside formal review processes included market changes, legislative or regulatory changes, competitor reviews, and feedback from stakeholders, including staff, reinsurers, legal, advisors, industry groups, and policy holders. Although the code introduced requirements for the review of medical definitions in on-sale products, it says nothing about the review of medical definitions in off-sale products. We asked the 10 life insurers to tell us about their process for reviewing and updating medical definitions in their off-sale products. Many of the life insurers said that they have a similar process for updating medical definitions in off-sale products as for on-sale products. Zurich said it had the same processes. AMP said it had the same processes, although considerations in the internal decision-making process in relation to whether updated definitions are passed back are different. MetLife said it has the same policies, except for the fact that on-sale products are reviewed at least every 18 months, but off-sale products are reviewed at least every 3 years. CMLA has the same policies for on and off-sale products. Its practice is to update the medical definitions in its on-sale products and then apply this update to all products to which those medical definitions are relevant, whether such products are on or off sale. MLC has the same review process for both products, although its current review of off-sale policies is restricted to those with a guarantee of upgrade. In the future, MLC anticipates reviewing medical definitions across all of its off-sale products. AIA uses the same review process, but has not committed to the same 3-year review for its off-sale products. It will only implement updates to off-sale products if they are beneficial to customers and if the product terms provide for it. Westpac adopts the same process, except that it only conducts such reviews at least every 3 years for off-sale products rather than annually. OnePath's legacy products are also generally subject to an annual product review in accordance with the product management guidelines. Where there is an update to an on-sale medical definition, an assessment will be done to determine whether the change can be passed back to customers of equivalent legacy products. TAL and Suncorp were the only entities that did not have a formal documented process for reviewing and updating medical definitions for off-sale products. TAL relies upon the operation of its guarantee of upgrade clauses to pass back updated medical definitions where it does not affect the level of premiums of pricing for the product. It also relies upon its obsolete criteria clauses, which broadly mean that advancements in medical practice that supersede an existing definition require an equivalent new measure to be applied unless this would materially disadvantage TAL. Suncorp only has informal processes and ad hoc medical definition updates in relation to its off-sale policies, though it completed an internal medical definitions review last year, and there are proposals to adopt a similar review every 3 years. Commissioner, could I tender the Life Code of Practice?
The Life Insurance Code of Practice, RCD 0021 0023 0001, Exhibit 6.176.
And could we have a brief break before turning to the next case study, which involves a different entity?
I come back at midday. Is that enough, or 5 past?
Yes. I'm in your hands, Commissioner. I'm not sure how long it will take the people at that end of the bar table to remove the many folders and be replaced with many more.
I come back at 5 past.
Thank you, Commissioner.